Okay, thanks for everyone's patience. We are now set up for this morning's calendar, which is almost all plea and arraignment, except for Mr. Smith at the very end. Our first position is Danny Jones. Mr. Jones is here. Good morning, Ms. Wood.
Good morning, Judge. This will be Ms. Feely's client, but I would like to speak to Mr. Jones, so if we could come back to this one.
Great. There's several cases here where maybe folks can talk and we'll see what happens. So Mr. Jones, if you'd sit tight, Ms. Wood is a colleague of Ms. Feely. They both are with the public defender's office. Just based on the number of your indictment, it goes to Ms. Feely, so they divide their work up, but they're partners. So Ms. Wood is going to talk with you, and please don't leave until she tells you it's okay to go. All right. Position 2 is Jeremy Prazo.
Judge, he's in custody.
Oh, and he's here. Hopefully he's here. Okay.
I would like to speak with him. I think we can resolve this today.
Great. Ms. Charles, positions 1 and 2 are both yours.
Yes, sir.
Great. Good morning. Position 3 is Farard Fallen. You're Mr. Great.
Judge, he's going to be my client. Same announcement. I'd like to speak with him and come back to this one.
All right, Mr. Fallen, Ms. Wood's going to talk to you, and I need you to sit tight till she says you can go or I, okay? Great. Catherine Sanders, I see online. There's Ms. Sanders. Good morning. Can you hear me?
Yes, I can hear you. How you doing, Judge?
I'm doing well. And we've got Mr. Reeves on the call as well. Mr. Reeves has filed a motion to withdraw as your attorney. We need to talk about how that's going to play out. Ms. Sanders, were you aware that Mr. Reeves was trying to withdraw?
Yes.
Okay. And Mr. Reeves, anything we need to discuss, or you and Ms. Sanders have covered this and she understands that from this point forward, you will no longer represent her?
That's correct, Your Honor. I have spoken at length with Ms. Sanders, and in fact, I'm trying to help her with her public defender application. I know that one of the co-defendants already has a public defender. I'm not certain if Metro Conflict Defender's office is still in play, but I was going to contact Ms. Mason with the conflict office to see how we can get her placed as soon as possible.
So this is an interesting indictment. The district attorney's office has elected to indict the victim alongside the alleged perpetrators of the shooting. The indictment alleges that Ms. Sanders and a Mr. Polio, I think is the name, or Polio, shot. I'm not remembering the name of the victim. And lo and behold, the victim is defendant number 3 in the case. So poor Ms. Charles, who I know did not draw up this indictment, is going to have some work to do. I'm not quite sure how representation will work in this case because I don't know how the state's going to talk to the victim in this case, because the victim, the alleged victim, is also a defendant, not Ms. Sanders. So who does your office represent, Ms. Wood, in the case? The alleged victim? Okay. All right. Ms. Sanders, I'm going to mute you. All right. You did it. Great. But if we have any questions, you can unmute and you can answer. So the public defender's office has Mr. Stewart, whatever the name of, I don't have the indictment in front of me.
Coleus, I think.
Coleus. Okay. You represent that individual. Does Polio have a lawyer?
I think there's a private attorney on that one. I think her name's Kimberly Banda, I believe.
Okay. And then Mr. Reeves was representing Ms. Sanders, but will be coming off. And it's your understanding, Mr. Reeves, that Ms. Sanders would qualify for appointed representation.
That's correct, Your Honor.
Okay. So it may well be that the conflict defender can take the case. And we do have a conflict defender, Mr. Cladis, who will be in a position perhaps to get the assignment. It will get much more complicated for Ms. Sanders if it has to go on to the C3 layer of representation. Now I'm looking at the indictment. So Ms. Bando represents Mr. Polio. Right now, Mr. Reeves represents Ms. Sanders. And then there's not it's not showing up that the public defender represents Mr. Stewart. I don't know if he's had his,
I know Miss Feely has the file for him, so we'll work on getting an entry in.
okay. There was a plea and arraignment about a month ago, and there's a scheduling order. Yeah, so someone needs to do an entry of appearance. All right. So.
And Your Honor,
yes.
Just for clarification, I have done a lot of C3 cases, so that's one of the reasons I'm trying to help Ms. Sanders if the conflict defender can't take it, because I don't want this case to linger any longer than it has. So I may still be sort of contacting the court to help her coordinate with the public defender's office.
Okay. And does it go as you roll off? Would Ms. Sanders's case go to the? I guess we know it wouldn't go to the public defender's office because they represent someone else charged in the indictment. So does it go to GPDC to then go to the conflict defender's office? That seems roundabout.
Unfortunately, I think that is the current situation. But as soon as we're done here, I'm actually going to try to call Ms. Mason, who's the head of the conflict office for the state.
Yep.
To kind of get some clarification. And what I'll do is once I get clarification on that process, I'll update the court as well, just to see how she's going to be able to get representation.
Okay. So Ms. Sanders, I think what we'll do is reset your case for a few weeks. It's fine for you to appear virtually like this until you and your lawyer connect. And then your lawyer may say, hey, I want you to come down to court so we can meet face to face. But as long as you are making an appearance, for your calendar, whatever your calendar is, virtual or in person, that's fine by me. Mr. Reeves is going to try to get your new lawyer assigned ASAP, but it's not always a super fast process. I may have my staff get involved as well, so that we can get the conflict defender to take a look at whether he can jump on the case. Does that make sense to you?
Yes.
I have as an address for you a Bolton Road address. Is that still where you are?
Yes.
So did you get something in the mail to be involved today?
Yes, I did.
Good. Well, we'll keep sending things to that address. If you move, you need to update it with the clerk's office because otherwise you'll miss court and then a warrant will be issued, okay?
Understood.
All right. Do you have any questions about anything?
No.
All right. Then Mr. Reeves, I will sign an order that allows you to withdraw. We'll work with the conflict defender to get Ms. Sanders a lawyer, and we'll set this back down for a plea and arraignment / status hearing a few weeks out.
And Your Honor, I have, in my experience, sending the order, and I can do it as well, to the public defender's office, the order of withdrawal kind of helps speed up that process.
Okay. Got it. Thank you. Ms. Sanders, any questions or anything else you want to discuss?
No, I really appreciate you all. Thank you.
All right. Mr. Reeves, anything else?
No, Your Honor.
All right. You two are free to go.
Thank you. Take care.
Thank you.
Damian Bennett.
Judge, he'll be mine. I anticipate, and ADA Charles and I have briefly talked about this, I anticipate doing a BHTC referral for him, but I would just like to speak with him before we enter the plea of not guilty.
Got it. Okay. Marvista Larry.
Judge, Miss Larry will be my client.
Is that Ms. I was looking down. Is that Ms. Larry? Hello, Ms. Larry. Okay,
If I could just speak to her judge and come back to this one.
yep. And then we've got a probation revocation in a case from 2011, Eddie Smith. And it lists Mr. Shores, who I think is now a prosecutor in Alabama. But he was, I remember Mr. Shores, nice guy. So is Mr. Smith here? Mr. Smith is here. I don't have the petition, so we'll need to look that up, see what the issues are. And it may be that this is something we can sort out. And I'm assuming for right now, it's just falling on your shoulders, Ms. Wood?
Yes, Judge.
Okay, all right. So let me recap where I think we are. No, I'm not going to be able to find the warrant. It's not in the normal places where I can find things. All right, so we'll work on that. Ms. Wood, you have a busy morning. You are going to chat with Mr. Jones. You're going to, folks who are out here, you can prioritize however you want, but Mr. Jones, Mr. Fallon, and Ms. Larry out here. And then we'll work on getting the revocation petition for Smith, and then you'll chat with Mr. Bennett briefly, and we can bring him out here to enter the plea of not guilty if that's how it's going to play out. And you'll chat with Mr. Prazo. I think that covered everyone.
Yes, Judge.
Okay. I will come back out here whenever there's something we need to do, whether it's get something on the record about waiving arraignment or something more. This afternoon, we have part 2 of an immunity motion hearing that I think Ms. Feely has taken over. Is that your understanding?
Yes, Judge.
Okay. That's Mr. Adkins, and Ms. Charles, you'll have whatever other, or I guess Ms. Feely, someone will have witnesses. I think we had heard from, it's Adkins, Adkins' wife or girlfriend, and then there is the alleged victim. Okay, great. All right. I am available as you need it.
Thank you, Judge.
You're welcome.
Okay. Mr. Jones, can you sit on hold?
Big smile. Mr. Smith, all right. All right. Ms. Charles, do you have the Smith warrant, or would you like a copy of that? How did you get it?
Stumbled upon it on City Park.
Okay. So I go to warrants, and sometimes, I mean, it lists all the warrants. Sometimes there's a little PDF icon. For more recent ones, it's almost like, this is an old warrant. This warrant.
You have to go under jail.
We have to go under jailings, because the 2 ways you find it in the case node is you can go to warrants, and sometimes it's there, or documents, and sometimes it's there. Oh, if you put it in there, okay.
We issue it one up and it gets attached as a document, which is really nice. And the clerk's office used to do it that way. That's why those were, but if you don't see it, then you have to go to jail.
Okay, and how? So we would have his booking number. So you'd look it up by booking number, and then,
Go to the jail. Well, I go in through, I look his name up, then I go click on his booking number, and I go under Atkins
Okay.
within jail.
Can you jump from one to the other? So like I'm in the case node now. Can you click on a booking number and it moves you over to the jail thing, or you have to?
Yeah, well, within the case though, yes.
So if I go back in, I'm gonna go into his case. So I'm in Eddie Smith's case, but I'm in the one where it shows the docket and all that. If I went to parties, so here's how I would do that. And I click on Eddie Smith,
Right?
and then I go to jailings. Yeah,
Then you go to jailing.
jailings, and there's a booking number that I can click on it. Yeah, I just clicked on it.
And then you go.
Oh, wow, he's aged a lot. Okay,
So you go to documents, go over till you get to documents,
yeah. Mugshot. Oh, booking package.
and that's when you.
Huh. Okay, so you can stay within the case thing and you go to the most recent booking number and that'll show why. And that's why instead of it just being the warrant, it's all this stuff because it's the whole intake package. It says booking. And,
Yes.
okay. Huh.
So that's what you.
Booking number. And then it goes, all right, I can probably remember that.
I'm sure you know.
That's good. This is a copy for Ms. Wood. Ms. Tucson?
Good morning.
Morning, how are you?
I am good. I'm talking to Miss Charles right at the moment.
Oh, I'm sorry to interrupt.
No, you're good.
I'm just trying to get ready for Eddie Smith. And his case is so old that his final disposition is not in Odyssey. And so I was wondering what his sentence was in this case and how much time remains.
No problem. I'm in the first one, the 10 SC.
Oh, there's more than one. Okay.
Yes, there are two. And I'll look and see if there's a copy of the indictment in here. There's 10 SC 94516.
Yeah.
Ends. Well, let me recalculate that. It ends in 2032. So
he's got 10 years left.
yes.
Okay.
And the other case,
Yeah.
11 SC, it ends 8/8/2032.
Okay. So he's got lots of probation left either way.
Correct.
All right. 10 years remaining. Okay. Thank you so much.
Okay, no problem.
So we'll do this first, one to the- and then we'll do the next. Mr. Fowl, is it Fallon or Fallon? Fallon, like you're starting to. Miss Larry, can you step out in the hall with us? How are you doing today? Good. One. Yes. Would you consider a misdemeanor old Larry? She tells me that she didn't actually use the plan. She was a little. She did. So. What she said. Oh, yeah, what she Okay, and then she lost that. She listens and she worked in McDonald's. So that's when she wasn't. So. He's drinking this into existence. Okay, so 24 months. Okay. Yeah. Okay. Thank you. Okay, she's like it. I'm gonna go. We'll take you off. Later, so I'm signing her up and then I'll go back there. Thank you. Okay, so I'm doing this person gonna need some kind of services. So I'm just gonna do not guilty all. Yes, Val. Okay. Saying Jones, he needs to talk to this. And then I'll talk to the other two after we sign out. Yes, I think, it looks like he was just revoked for a year, so I think that should resolve. Out of LRB. I think so. Look and see. It's an old case, 13 SC. They're not just revoked, it looks like he was revoked in October, but he was revoked a year. 117542. Okay. Okay, I'll go sign her up real quick and then I'll talk to the. Thank you. Okay, so we're going to talk to these gentlemen and then. Yes, so we'll talk to them, see what they want to do, and then we'll come back. Okay. Do you want to come back here? Yeah. I don't know. He said he wasn't there. He was doing other calls. You're right. So, hey, how are you? Good. We have two gentlemen back here. You want to see them? Yay, Jeremy Croson first. Okay. So that's what I wanted to talk about. Do you believe so they would have to do a referral, and then they would do the next couple. And then they get back to me. So you have the option if you want to go out.
I'll be staying in my I will take care of the. That's one area for. Yeah, I was very hard.
So how long did you say the state? So you're on the grader today, okay? So I think you would ask the judge, so. On argument, I would be concerned too much. On this decision, which the judge couldn't.
Okay,
So, are you completely against me?
I'll do that.
Okay, so I think that's probably going to do this. Okay, so we'll be comfortable with that. We have I think you know what the page that
We're better than that.
maybe not much of it. You're welcome to do it. Who's present? Yes. Hi, are you Mr. Prozo? Okay, my name is Lacey. I'm going to introduce you're on the theater ratings today. I have an offer the state of it today. Okay. I can see the information hires. So if you're interested in it, that today. It was and it was
Same.
so we have like 9 years of information
I was in 19, so it's gonna be long. So that was.
Okay. So you right, okay. For the state of districts. And I offered you for your information, I'm sure what your credit to all those here, correct? And then just is that something? So we agree, so for official officers for what credit? Okay, so you're almost done. So. Yeah.
No, I mean, we can figure one at a time.
So, no, so we can get it. We can ask for sure. Okay, so what I'm gonna do is I'm just rolling. We'll have a great
Yeah.
Thank you. She's just wrapping up the paperwork for me. So, yeah, that's totally fine. This will go through either way, but I just. This guy, so he's been in since August of last year, so he's been in, what, 10 months? Oh, is that right? Yeah. So he asked me if we consider just the 3 years to serve for the holidays and the Yeah. Yes. That's right. That's what I asked, but he's cool with going forward. That's the Okay. Right, yeah, so, okay. So we signed him up, he should be coming out soon, and then, this Larry is also. Yes, something. I'm gonna refer him, he is, and he also was called to stay over there. So I tried to reach out to him yesterday, but no one, I left messages, and so. Well, he said that I haven't been able to get the one, so I'm gonna do not guilty and then figure that out. Yeah. Thank you. It's fine. I'm happy to.
All right. We've got fewer people in the courtroom now. Let's go through the calendar again, and then you guys can let me know what the plan is. Mr. Jones.
Yes, Judge. I spoke with him, confirmed his address, got good numbers for him, and I'm gonna do a waiver for Miss Feely for him.
All right, so waive and schedule.
Yes.
All right, thank you for covering for her. Does this seem like a work-outable situation or TB? I know he's a repeat offender and there may be a big gap, but.
I think so, Judge. He was having some health issues, so that's why I thought that maybe he should go today, and then Miss Feely or I, or whoever could talk to him and.
Oh, he was having health issues right now?
Yeah.
Okay, got it. Mr. Prazo.
That's gonna be a plea, Judge.
Great. Mr. Fallon.
I'm gonna waive for Mr. Fallon as well. I believe some services will be required for that one.
Okay, yeah, he seemed like maybe there were health issues going on. I hope he's okay. So we'll do a scheduling order for that. Ms. Sanders, we'll talk to Mr. Cladis about Mr. Bennett.
Judge, I'm gonna waive an interim plea of not guilty for him. I'm also planning to do a referral for accountability court.
Okay, you had said BHTC, you're not sure which one, they'll let them decide, or you think it's?
It'll be BHTC.
Okay, all right. Do you need Mr. Bennett to come to the door to hear that or actually sit with you? Okay.
If possible.
Sure. We'll probably do that before we bring Mr. Prazo out, just because then Mr. Bennett will be taken care of. Ms. Larry is still here.
Yes, this will be a plea today, Judge.
Great. Okay. And then Mr. Smith, hopefully you got a copy of the warrant. It involves stuff from long ago.
Yes, Judge. I forgot to talk to him back there, but I'm happy to.
Okay.
We can work through this.
Well, why don't we take care of Mr. Bennett, and then we could do Ms. Larry's plea since she's out here, and then we'll do Mr. Prazo's unless that sequence of events makes people sad. No?
Thank you.
Okay. All right. Hope it won't make anyone sad. Hey, Mr. Bennett, you come a little further so I can see you. Hey, I'm Judge McBurney. How are you? Good. Mr. Bennett, I just want to let you know that I spoke with Ms. Wood, your lawyer, and she told me that we're going to get a scheduling order in place to make sure your case is moving along, and that she's going to have some people from our accountability court come meet with you to see if maybe participating in that program would be a good way to get you some assistance and work through this case. If people come out to talk to you about being in an accountability court, will you meet with them?
Yeah.
Great. Well, I'm gonna have them talk with you, and then we'll all get back together to figure out what the right next step is in your case. I just wanted to introduce myself and let you know that Ms. Wood shared with me some of her conversation with you. Some of it's confidential, so I don't need to share that with me, but she's letting me know that she thinks it would be a good idea to have the accountability court people come meet with you. And we'll do that. That'll be our next step. And if they'll accept you into the program and you're willing to do the program, then we'll probably have a conversation about that, either with you coming to court or you being on Zoom from the jail, and we'll handle it that way. You have any questions about any of that?
Yes. How long does it take before they prove it, like or when if I go to court, could I even at that moment would y'all do like a signature bond or something?
So if you are admitted into the accountability court, then Ms. Wood and the prosecutor, Ms. Charles over there, need to decide if this case you get into accountability court as what we call a diversionary track. So you're not pleading guilty, or if it would be a plea, you're alleged to have busted something up, as best I can tell. If you entered a plea, then your sentence would be release Mr. Bennett to accountability court. They can help you with housing, get you situated. You may not need housing, you may have a place to stay, but if you don't, they can help you find a place to stay. And so if it's that approach, you don't need a bond because you will have pled guilty. But if it's the other approach where you're not pleading guilty and it's what we call a diversion, then yes, I would have to set a bond so that you could get out. And this charge is one where I could do a signature bond. We're not doing any of that quite yet because we want to make sure you're eligible for the program, and we don't want to just have you be out and about. We want to make sure there's some structure for you. Okay?
I could go to my grandmother's apartment and therefore, well, her trailer, yes, and therefore stay with my grandmother, and that's fine.
Okay. Well, and you know what? The folks from accountability court will talk to you about that, because we need to make sure you had a way to get from your mother's apartment or trailer to Hope Hall, where court happens. And if transportation is tricky, or maybe she's out in Covington or somewhere far away, then we might want you to be a little closer. But I wouldn't worry about those details. I would just be ready to have a good conversation with the people from accountability court so they can get a good sense of your needs, and you can let them know your willingness to participate. Okay? I would think they'd be there next week. I know, well, it's only Tuesday. I know that Ms. Wood will put in the request, and they go out fairly regularly. Hope Hall is a couple buildings that are about 200 yards from the jail. So it's not hard for them to get there. And they go on a pretty regular basis and ask the detention officers, hey, could you bring Mr. Bennett to the interview room? We'll have a conversation, handle it that way. Okay? All right. We'll see you soon.
Thank you. Have a blessed day.
You too.
Thank you, Judge.
You're welcome. He was getting all cash against the wall there. I like that. Leaning up there. Ms. Lay, why don't you come on up to the podium, please?
It's a lot.
No, it's fine. I just, he might ask some questions.
It's still to want to know if that means it's just not going out to 29.
Oh, whoever was first out is first out still. Yeah, I was worried about that. I should probably send an email saying just because you're on the July 11th calendar doesn't mean you're off June 29th. There's great news about Hodges too. I'm just getting your indictment up on the screen here. Ms. Larry, give me one sec. Oh, you did? Oh, I didn't. Just you recently added it? Oh, to the calendar invite? Oh, okay. Sometimes you have emailed it in the past, so I should look to the calendar invite. I'll find the other one there. Okay, great. Thank you. All right, I've got your indictment up. Ready, Ms. Rivers? This is State versus Marvista, Larry, 22 SC 182321. And Ms. Wood, representing Ms. Larry, both of whom are here in court, indicated that Ms. Larry would be entering a plea. In a moment, Ms. Larry, Ms. Charles is going to put you under oath. Once you're under oath, it's important that you answer all of her questions as well as my questions truthfully and as completely as you can. I'd also ask you to let me or Ms. Wood know if you have any questions. I'll ask at the end, hey, do you have any questions? But something may come up partway through where you don't quite follow what someone said, or you don't hear it, or it just is not going the way you thought it was going to go. And if you reach that point of confusion or concern, we should stop. You and Ms. Wood can talk. She can try to answer your question. I can try to answer your question. But will you let us know if you've got any questions?
Yes, sir.
Great. All right. And when you're answering questions, you'll be doing a fair amount of talking. Make sure you speak up. You're welcome to take your mask off if you want. I'm not requiring that. But for folks who are talking, I generally invite them to have the mask off so that we can hear and a good record can be made. When you're ready, Ms. Charles.
Yes, Your Honor, thank you. Your Honor, before we proceed, the state will be moving to reduce the charges from terroristic threats to disorderly conduct pursuant to Code Section 161139 on both counts. So it'll be 2 counts of disorderly conduct.
Okay.
Ms. Larry, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your true, correct, and legal name for the record.
Marvista Larry,
Can you spell Marvista?
Marvista.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you? How far have you gone to school?
32, GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you're being charged with the following offenses in indictment 22 SC 182321, 2 counts of disorderly conduct?
Yes,
Have you reviewed the waiver of rights from your attorney?
I have.
Have you had enough time to speak with your attorney, Ms. Wood, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Counsel, do you waive any and all defects in the indictment?
So waived for purposes of this hearing.
Ms. Larry, have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you, Ms. Larry, or your attorney know of any outstanding warrants relating to these charges?
No,
We
ma'am.
do not.
Ms. Larry, has your attorney advised you the minimum and maximum sentence for each charge you're pleading to today?
Yes.
For the record, the minimum being 1 day, maximum being 12 months per count. Do you understand, Ms. Larry, that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 24 months probation, successful completion of an anger management program, 80 hours of community service, and a stay away from the location of the incident?
Yes.
Stay away from location, but not from Sims and Williams? Okay.
Stay away from the location and victims.
Doesn't sound like there's like a train rolling by. Quite sure what it is going on in the sheriff's office.
Do you understand, Ms. Larry, that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Are you a US citizen?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
I'm sorry, could you repeat it one more time?
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes, ma'am.
Do you understand that if you had gone to trial, you would have had the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against
Bless
you, the right to assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted after a trial on these charges.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Ms. Larry, how do you plead to the charges in indictment 22 SC 182-321 of 2 counts of disorderly conduct?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you may only have 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, the state is unaware of any criminal history for Ms. Larry. And had this case gone to trial, the state would have expected to prove that on December 14th, 2021, at approximately 7:27 p.m., officers responded to 5255 Old National Highway on South Fulton, Georgia. It was a Wendy's restaurant. There they met with restaurant manager Akila Sims, and Ms. Sims indicated that Ms. Larry had come into the driveway and got into a verbal altercation regarding her order that she had placed in the drive-through. Ms. Larry proceeded to yell at Ms. Sims, as well as another employee, Mr. Shimon Williams, that she knows what time they close, she will be back, and they will be dead messing with her, and she would blow their heads off. Part of this interaction have been covered on the camera and in the drive-through. When officers came to the scene, Ms. Larry was no longer there. There was no damage done to the windows or anything of that nature. No gun was found or anything of that nature. Ms. Larry then came back around to the drive-through, it appears, and then made another threat saying, I'll come back tomorrow. I know what time you will close, and also made some negative slurs against Mr. Williams. That was all that occurred, Your Honor. Ms. Larry was then arrested and charged accordingly.
What was the street address? Old National Highway. What were the digits?
5255.
5255. And how did Ms. Larry ultimately get arrested? She came back while the police were still there?
Confirm, Your Honor.
In Atlanta, out by, Cleveland Highway.
Okay.
Yeah.
And may I have Ms. Larry confirm? I don't see that.
Sure.
I wasn't at, I was, on the other side of town. I was on Cleveland Avenue when I was arrested by Atlanta police.
Okay.
And I was not at the scene when the officers came. I had left the property.
Okay. I'm just curious how they connected the dots, unless Miss Larry said, and by the way, I'm gonna come back and blow your head off, and I'm Mar Vista Larry. Don't forget about me. Remember that name, Mar Vista.
There was a Miss Sims had a very clear video that she showed officers that captured Miss Larry on video and making the interactions. And that if they put out the request for her arrest, they would look to match the photos when she was subsequently arrested. So.
But that's like technology we don't have. That just because they had a pic. I was curious if they got a license plate. It's not critical. I'm just curious.
When I was leaving, she got my license plate. That's how they got who I was. Yeah, it was no camera.
Okay, I mean, they may have gotten you as well, but we currently, not in this country, I don't think, have the ability like, aha, here's the face and there's the face now on Cleveland Avenue. It would likely be a tag, but either way, you've helped me understand the flavor of it. It was a bad ordering experience at Wendy's. Okay, anything else?
No, Your Honor, just to confirm that is correct. She was confirmed for her Nissan Pathfinder license tag came back.
Got it. It's always the vehicle.
Registered to her.
Okay. Ms. Tucson, do you have any adult felony criminal history for Ms. Larry?
No, Judge. She has no criminal record.
Okay. And Ms. Jackson, any cycles beyond this for Ms. Larry?
The defendant has 2 cycles. The defendant's last arrest was June the 5th, 2020 in Griffin, Georgia, for cruelty to children in the 3rd degree. There were 9 counts and battery, family violence, but there was no disposition for it, Your Honor. Nothing in addition.
Thank you so much. Ms. Wood.
Thank you, Judge. Miss Larry is 32 years old. She is a lifelong resident of Georgia. She has 8 children. She does have her GED. She was, at the time of this incident, working for Uber. She lost that job due to this pending felony. She is currently working at McDonald's. Judge, she may want to speak to the court, I'm not sure, but in our discussions about the case, there was a heated moment at the drive-through. She does dispute the exact words used in the police report. Nonetheless, we do feel this is a reasonable offer and a good resolution for this case. And so we just ask that you accept the state's recommendation. And Ms. Larry, if you would like to speak to the judge, you may.
Sure. I got a couple questions first, and then you can share anything you want to share.
That's fine.
What happened to your Griffin case? Was that dismissed? Is it still rattling around out there?
No, it's I haven't been to court for that. Yeah, it was with my children's father. I still don't understand why I got arrested for that. The counts are for my kids. When I did talk to a judge, he told me the best thing for me to do to cover myself was to put out a PTO out on on my children's father, because that was.
Okay, and I wasn't asking you so much about the facts as do you still have to go down there? You think it's been resolved as far as your part was?
Yeah, because he told me what to do, and then I was able to be with my kids, and it was that.
Okay, got it. So it's December 14th of last year. You go to Wendy's to order. What possibly went wrong such that the exact words don't matter so much, and the way we're resolving this now seems like a better fit because it sounds like it was disorderly conduct. You were yelling, maybe they were yelling, but you now work at a Mickey D's. You know about customer service. What? I
had been worked at McDonald's before. Okay, I had been a manager at the top of Old National, so I know how customers are. So I would never go in rude with anybody. But the young man that was at the window, he was very rude and very nasty. And I had my kids with me. And my kids, they're 7, 8, 9, so they understand when somebody being rude.
Yeah.
I just asked for some barbecue sauce. It wasn't that serious for my daughter, because he was like, well, I already gave it to you. And I was like, well, sir, I know you didn't give it to me because the first time I didn't even ask for none. but she kept whining about it. So I asked for some, and he just threw it in my hand along with my change, along with my lemonade. And I asked him, could I speak with a manager?
Okay, and that's when Miss Sims gets in the mix.
No, she wasn't even in the mix yet. He didn't even go get her at first. So I was like, well, I will sit here until I can talk to a manager, because he was very nasty.
Yeah.
And that's when she came, and she was very nasty. So in order to cover their self, because I asked, could I get the district manager on both of them? And I also tried to call the Wendy's corporate while I was sitting there. That's why I was sitting in front of their window.
Okay.
Yeah. And when that went down and they didn't video me, I was videoing them being rude. I did speak with the district manager the next morning, and my words was never, I will blow your head off or any of that. My words to them was that I will see if you have a job tomorrow, not that I will see you tomorrow.
Okay.
And of course, to cover their butts, because they see me calling her, and then they tried to call her. And of course, she answered for them because it's a running operation. I did get in touch with her the next morning, and me and her talked, and I let her know what's going on.
Her meaning the district
The
manager?
district man, I can't remember her name, but the district manager. Yeah, and she agreed that the young man was very rude, and it's not his first altercation with anybody. And like, so it's a long story behind that, along with some officers that had asked me what was going on while I was in the back of their seat, and they know who he was too. And I was like, that's sad that everybody know who exactly this one person is. And Miss Sims, that's her name, Miss Sims. I don't even know who she is. She just came in. She didn't want to talk because she was rude too. So I just pulled off. And then she said, I'm calling the police. So then that's when I came and parked. And I was like, okay, well, the police don't come. I can tell them my side. They never came. And then I left.
Okay.
And that was just the end of that. And then when like a couple of days later, I was getting pulled over in Atlanta for a terrorist threat.
And here we are.
Yeah, and here I am.
All right. Well, I appreciate you sharing that. I understand that it's been reduced to disorderly conduct, and I do find there's a factual basis for that. Those kind of charges, you almost could flip a coin. They could charge maybe Mr. Williams because he was being disorderly. I wasn't there. That's not how it played out. I understand why you're frustrated by it.
I know that it could have been flipped the other way, but I didn't know at the time until now that I'm experiencing it.
Yep. I also find that your plea is knowing and voluntary. Voluntary means that you're moving forward with this misdemeanor plea because you've decided after talking with Ms. Wood that it's in your best interest to do so. You may not be excited about it, but no one's forcing you to do it. Is that fair?
No one's forcing me, yeah.
Okay. And then a knowing plea is just one where you've understood the things we talked about. And if you didn't, you asked about them and you've had a chance to explain your perspective.
Yeah.
So I'll follow the recommendation. Actually, I'm going to modify it a little bit. I'm going to give you 18 months probation. So on count one, it will be 9 months. And count two, it will be 9 months. Count two will run consecutive to, meaning right after the other. So it's a total of 18 months probation, all misdemeanor. I will ask that it will be a special condition of your probation that you complete an anger management course. That will probably also help insofar as you have to deal with the father of your kids. It sounds like that's a tumultuous situation as well. And this will just be
that's a done situation.
Okay.
Yeah, I'm not putting myself through that or my kids. Oh yeah, that's a done situation.
Okay. Well, however it is, this will help. You'll need to do 80 hours of community service. You don't have to do that on day one or week one. You can spread it out, but you'll need to take care of that. And then you'll need to stay away from the Wendy's while you're on probation at 5255 Old National Highway. And I think this one will be easy for you. Stay away from Mr. Williams, the guy who didn't want to give you the barbecue sauce, and then Ms. Sims, his supervisor.
Yes.
All right. The last thing I've got is that your indictment is actually right now an electronic document. I've got up on my screen. Do you authorize me, Ms. Larry, to sign it for you, indicating your guilty plea?
Yeah.
Ms. Wood?
Yes, Judge.
And Ms. Charles? Great. I will do that. Ms. Charles, anything else in Ms. Larry's case?
No, Your Honor.
No, Ms. Wood? Okay. Does Ms. Larry need to wait here for misdemeanor probation? Okay. So I'm going to sign your final disposition in about 2 minutes. Then Ms. Nelson will call misdemeanor probation and they'll come in here just to let you know where you report for your first whatever your first thing is, and you'll be off and running. Okay.
All right,
Good luck with everything.
thank you.
Get my email. I'm just gonna write it down in case you have any questions.
So Deputy Gordon, when you're ready, although we need to let's wait till Ms. Wood is done chatting with Ms. Larry.
Okay, yeah, just, call me everything. Yeah.
Can we bring Mr. Prazo out?
Yes, Judge.
Great.
Judge, would you like this? I filled it out just in case.
Sure, I didn't know you had. That'd be great.
Okay.
You may. Thank you. One second.
They're gonna make someone in prison. The last 45 days.
Really?
Mhm.
If you don't, we don't have to.
When we reset again.
That's the thing.
Yeah.
I'm not sure. I know.
Are we good?
I believe so, Judge.
All right. How do you pronounce your last name?
Prozo.
Prozo. All right, Mr. Prozo. I'm Judge McBurney. Good to meet you. Mr. Prozo, Ms. Wood tells me that you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
For us to do that, Ms. Charles, who's the prosecutor, is going to put you under oath. And then she's going to have a bunch of questions for you about your rights, et cetera. I may have a few. You need to answer all those questions truthfully and completely. But you also may have questions, which is perfectly natural. You're welcome to ask me. They may be questions you want to ask Ms. Wood. My request of you is that you simply let us know if at any point we ought to stop so that you can ask your question that just cropped up because of something someone said. Will you do that?
Okay.
Great. Your case is 22 SC 181043, and Ms. Charles is going to take it from here.
Your Honor. Mr. Prozo, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand.
Ma'am?
You may lower your hand.
Okay. Sorry.
State your true, correct, and legal name.
Jeremy Bryan Prozo.
How old are you and how far have you gone to school?
I'm 44 and I went through college.
Mr. Prozo, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Ma'am.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you're being charged with the following offenses? Possession of methamphetamine, possession and use of drug-related objects, knowingly driving a motor vehicle on a suspended registration, and driving with no insurance.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you reviewed the waiver of rights form with your attorney?
Yes.
Have you had enough time to speak with your lawyer, Ms. Wood, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment?
So waived for purposes of this hearing.
Mr. Perzo, were you arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No.
We do not.
Has your attorney advised you of the minimum or maximum sentences for the charges you are pleading to today?
Yes.
Count 1, possession of methamphetamine less than 1 gram, 1 to 3 years. Counts 2, possession of drug-related objects, 12 months. Counts 3, knowingly driving a motor vehicle, 12 months, and driving with no insurance, also a misdemeanor, 12 months. Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 3 years to serve 1 with credit for time served, that you would complete as a special condition probation substance abuse evaluation and follow all recommended treatment?
Okay, yes.
You understand that this plea may be used to enhance sentencing and other convictions in this jurisdiction, as well as in other jurisdictions, including federal courts.
Yes.
Do you understand that if you are currently on probation, your probation may be revoked based on your entering a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess, use, or use a firearm while on probation?
Yes.
Are you a US citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction after a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in any crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes.
Do you understand that if you had gone to trial, you would have had the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify, remain silent, and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not to incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Mr. Prozo, how do you plead to the charges of possession of methamphetamine, possession and use of drug-related objects, knowingly driving a motor vehicle on suspended registration, and no insurance?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for the misdemeanor charges to file a habeas corpus petition challenging the voluntariness of your guilty plea?
Yes.
Your Honor, the state is aware of 5 previous felony convictions for Mr. Prozo, one of which is currently on probation.
So I have 7 on the repeat offender transfer form.
Okay, I'll defer to Your Honor.
Okay, I mean, I'll defer to your office, which probably provided it to Judge Brooks, but the oldest was a 2009 sale of cocaine, and the most recent is a 2019 financial transaction card fraud. And there are a bunch in between, including one from Coweta.
Thank you, Your Honor. Your Honor, had this case proceeded to trial, the state would have shown that on August 1st, 2021, officers were on patrol in the area of I-85 and Cheshire Bridge Road when they observed a vehicle parked with the headlights on in the parking lot of a closed business at 2499 Chantilly Drive Northeast. Officers conducted an inquiry of the vehicle's tag, which came back registered to the defendant, Mr. Jeremy Prozo. The vehicle's registration came back suspended and that there was no valid insurance. Officers then conducted a traffic stop. While speaking with the defendant, officers noticed the tip of a needle in the center console and the blue case in the center console, which is near Mr. Prozo's hip. When asked whether there was any drug paraphernalia in the vehicle, the defendant denied that there were. The defendant was subsequently detained and officers conducted an inventory of the vehicle, a search of the vehicle, and officers located in that blue case 3 unused needles and a quantity of methamphetamine and a small quantity of baggies, clear baggies. The methamphetamine was subsequently tested by GBI as and confirmed to be methamphetamine in an amount of less than 1 gram.
Which is why it's 1 to 3.
Yes, Your Honor.
Okay.
Mr. Prozo to date has been in custody for 311 days. And I believe he was revoked, correct? In the case ended in 13 SC 11752 in 2021, 1 year as well, which is currently serving. And so we ask that the 3 served one would run concurrent and he'll go back on probation and the conditions will continue to run concurrent with his current probation.
Okay, thank you. Ms. Tucson, Mr. Prozo's got a bunch of cases. Is the 13 SC case the only one that's open and active with DCS?
No, Judge. It's that one you mentioned, 13 SC 117542, and then 19 SC 166821.
Those are both open. Okay.
That's correct.
How much? It sounds like Mr. Prozo's already been revoked in connection with this conduct, this arrest in the 13 SC case. Did that also happen in the 19 SC case?
I don't see it right at the moment. I know there's a lot of time remaining on both cases. He's not in warrant status at the moment. I'll have to look up if there was a previous revocation. On the 19 SC, he has 5 years, 11 months, and 7 days remaining.
Okay. And I'm asking only so that we can handle it all here. It looks like there is a probation revocation order in the 19 SC case from September 7th, Judge Richardson. Yep, it relates to this. And so she revoked 3 months and continued him on probation. Okay.
In the 13 SC, right?
Well, it's the 19 SC is what I just looked at. So let me look up.
Put on the 13 SC as well.
Yes. The 13 SC was revoked by Judge Ellerby, and then the 19 SC was revoked by Judge Richardson.
Got it. Okay. So this conviction won't rear up and ought not to cause any revocation issues with those 2 open cases, the 19 SC and the 13 SC. That's all I was getting at. Okay. Thank you. And Ms. Jackson, how many total cycles do you have for Mr. Prozo? And do you have any out-of-state activity?
There's a total of 18 cycles, 15 in Georgia and 3 in Alabama.
Any Alabama convictions?
There were no convictions in Alabama. Oh, there was just a misdemeanor. And that was in 2000 for a DUI.
Got it. Okay. Thank you.
Yes, Your Honor.
Ms. Wood.
Thank you, Judge. Mr. Prozo is 44 years old. He is originally from Alabama. He's lived here in Georgia the past 21 years. As he mentioned earlier, he is a high school graduate as well as a college graduate. He has a degree in marketing from Auburn. He was working in the service industry prior to this arrest. Judge, once he's done with all of his legal issues, he's going to be able to live with his parents down in Henry County. So we did want to let you know that he does have a safe, stable place to go to. And we're just asking for the credit for the 311 days that he has already served. He also wanted me to share with the court that he's been a trustee at the jail this entire time. So we just ask that you accept the state's recommendation on this case.
Okay. Mr. Prozo, why do you think when you get out, life in Henry County in a safe, stable residence will be one where you aren't getting pulled back into your addiction? As I look at your criminal history, what this was, and I'm familiar with Cheshire Bridge and all that kind of stuff, I just worry about you. I worry that in 2 years, you'll get arrested again because your addiction is controlling your decisions rather than you controlling them. And this resolution, other than you submitting to a drug and alcohol evaluation and then following up with treatment, which maybe be going to some AA classes or NA classes or whatever, doesn't make me feel real confident that you're going to beat this thing that for a decade plus has been beating you.
Correct. Well, I think the safety of my parents' house is not a long-term. It's not a long-term solution. It's a solution to be able to get me started, because the last time when I relapsed, I was relapsing the program I was in, and they kicked me out for 5 days. I wasn't aware that was this rule. I went back and I told them, hey, I messed up. And so I went and picked up my car, and I was living in my car for the 5 days. And that's when I got arrested.
What was the program you were in?
Sober Living America, which I'm not going to speak about them, but it's not a place to really recover. It's a place where you work and pay them money. And but I still relapsed. But I did go back and I told them the truth. I didn't realize that I was going to get put on the street. And so I made a lot of bad decisions in those 7 days. And because I relapsed for 2 and then went back and they kicked me out. So my parents' house is a jump off spot. It's a place to get started. It's a safe place to get started. I don't plan to live there more than probably 30 days. My dad is a retired pediatrician, and they've been looking for rehabs to put me in, like far away from home, because obviously I know now at this point, and I've known for several years, that I can't live in the Atlanta area. Ever since I moved here, it's like small town caught up with the big city, and it really swept me up. I've learned a lot in these past 20 months. I've been in jail for 20 out of 21 months. I was out for 18 days. And I'm thankful for that because I'm healthy, number one. But number two, I'm just tired of it. I'm tired.
Well, and that's a motivator. I'm one of the drug court judges, which is why I'm asking all this, because boy, when I started looking at your case, like, great, you guys are going to say drug court. You're going to stack the misdemeanor, so we've got enough time for you to go to drug court. And that's not the disposition. I'm not going to disrupt the disposition. But you seem like you'd be a good candidate for a structured program like that, that helps you. I know right now, you're like, look, I'm healthy, I'm clean, until you're not, because you get out and you say you're going to leave Atlanta, but you don't. And you go around to a place like, you know what, I'm just going to visit my friend one time, and then relapse, and you're living in your car again. Then you get arrested, and we repeat this cycle, even though you're tired of it, because you don't have the tools and the support network that will help you. It is rarely one person beats the addiction. It is usually a group that helps the person through it.
And I agree with you. You know, when the first attorney had, I'm not sure of her name, her assistant called me and he was talking about drug court. And I said, hey, I would have been loving it, but I've graduated from drug court and I've been judged down to 2011. And that was the longest time I ever stayed clean. And you know, I've just got to find a program that's going to be stable for me and that accepts me for my lifestyle. And it's going to be somewhere far away, and it's going to be somewhere more accepting. And I think that's what one of my main problems is that I got a lot of personal things I need to work through, and there's a lot of therapy, and there's a lot of help that I need. And I know that, and I'm not running from it. And this past time was just, I'm so mad at myself still because I was on a good path, you know. But I'm in agreement with you. I mean, I've got to have a program, and I'm not talking a 6-month little program, but I'm going to go somewhere where I can go and live and work there. Because as long as I'm connected, I'm cool. I'm great. I get along with people, and I don't have any issues. But you know, and I'm in agreement with that. And I think that's the jumping off spot. And my parents care for me. They will, you know, cut me off if things go bad, but they are there to help. And
That's good. That's a real important resource, because the folks who are most adrift that I encounter as they head into drug court don't have that piece. There isn't the jumping off point.
Yeah.
There's no sanctuary. And then we have to help them create that and see where we go. All right. Well, the first step is knowing you need help, and you clearly know that, and you articulate that well. And you, it sounds like you've got a notion for what would be a program that is durable for you. And it's going to need to have a number of facets, not just the addiction treatment, but there are other parts of it that will make it more effective for you. Well, I find there's a factual basis for your plea. And also that your plea is knowing and voluntary. No one's forcing you to enter this plea.
No.
You don't have any questions about anything? Or do you have any questions? It's okay if you do. Anything you want to talk about?
No, I don't have any questions or anything. It's, you know, I was hoping to avoid the full year, but I understand it's a DA. That's what they want. It's just
Well, and I'm not going to say it's just the DA. If it had been time served, not going directly into a program, I would have said that's not how it's playing out.
Yeah.
Your criminal history is such that there need to be consequences for these. You're not hurting other people. Your financial transaction card fraud might have economically hurt someone, but you're hurting yourself.
Yeah.
And so I don't think this sentence reflects, we need to incapacitate Mr. Prozo because he's out there doing these things that are hurtful to others. But how many convictions do we need before we say you're going to go away for a while if you're not going to embrace the treatment in a way where it's making a difference? So I don't fault the sentence. I wouldn't fault it if it was a little longer, but I'm not going to extend it. Do you have other questions or things you want to bring to the fore?
No.
Good.
Yeah.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. And what that means is that while you're on probation, if you have a minor or a technical violation, you and probation will work that out. But if it's significant, getting arrested again would be significant. A single positive drug screen, that's a technical violation. 5, and there's nothing magic about 5, it could be 3, but multiple, especially in a short period, that might rise to the level where probation says we need to get them back in front of the judge. Although usually the sanction ceiling, the things that probation can do to try to improve your behavior without coming to me, includes a day reporting center and the detention center. So it could be the outcome of, these are all hypotheticals, you keep testing positive, is that they modify your probation to say you're doing the day reporting center, which isn't going to be all that different from drug court you did 10 years ago, but hopefully it's new and improved in some ways. Do you have a plea form?
Yes.
You signed that plea form that Ms. Wood covered with you, Mr. Prozo?
Yes, I did. Great.
Ms. Wood, you signed it?
Yes, Judge.
Mr. Prozo, I've got your indictment on my screen here rather than printing it out and having everyone sign it. In person, do you authorize me to sign your indictment electronically?
I do.
Ms. Wood?
Yes, Judge.
And Ms. Charles? All right, that's taken care of. What does it mean to say that you work in the service industry?
Bartender, server, cater, waiter, events, break it down, build it, everything that involves like weddings.
Okay.
Anything like that.
Do you know the specific address of your folks in Henry County?
Mm-hmm.
All right, you don't need to tell me, but you're gonna need to share with probation in just a minute. All right. So, Mr. Prozo, I'm gonna sentence you on count 1 to 3 years to serve 1 year with a balance on probation. Count 2, I'm sentencing you to 12 months probation. I'm going to run that consecutive to count 1, and counts 3 and 4, also 12 months, which I'll probate, and I'll run those concurrently with count 2. So I'm making your sentence a little bit different. Instead of 3 years to serve 1, it's going to be 4 years to serve 1. And the simple reason is I want a little more time on probation so that if this path that you've described for me is something that ends up not being particularly productive, and probation is reaching out to me saying he keeps testing positive, there was a misdemeanor arrest for shoplifting, something that to me is a hallmark of you continue to struggle with the addiction, I've got enough time to work with maybe saying we're going to try drug court again, because drug court here might accept you. Drug court in Henry County might accept you. Some things bear repeating. And I want a little more time on probation to have that ability. 2 years probation is cutting it real close. Unless I got you into drug court in the next couple months, you wouldn't have enough time to get through drug court because it's an 18-month program or longer if you're struggling with it. Correct. So that's why I'm extending it. You will get credit for all the time you've been in. The sheriff may decide you've done enough of 1 year that you get out. Now, you've got these other revocations that may make that more complicated. I don't know. Although the case with Judge Richardson, you've already done the 3 months. So that's done. And it will be a special condition of your probation that you submit to a drug and alcohol abuse evaluation. Probation will help set that up. And if that professional meets with you and says, you know what, Mr. Prozo, you need to do X and Y and Z, that course of treatment that is recommended will become a special condition of your probation. And the only significance of that word special is that if you are violating a special condition, I can work with all of your probation in fashioning a resolution. If you just have a technical violation, there are limits as to how much I could revoke or what I could do. But I like having flexibility, so we can do that. Ms. Charles, anything else in Mr. Prozo's case? Ms. Wood?
No, Your Honor.
All right, you're going to need, Ms. Tucson is going to appear on the screen in front of you, and she's going to ask you some logistical questions, where you're going to live in Henry County, and explain that that's where you'll need to report initially, and all of your probation, because it sounds like you'll have 3 cases, that'll be transferred to Henry while you're living there. When you move, you got to let probation know, because your probation follows you, and it will be you'll get a different officer and it'll be supervised wherever you go. Last counsel, when you say you're going to go to someplace far away for treatment, you may, but moving out of Georgia requires some paperwork to be done. You can't just willy-nilly say, I found in Arizona the right place for me. It may well be, but your probation would have to be transferred there before you can move to Arizona, or you will be deemed to have absconded, and then we'll probably have to spend more time together.
Okay.
All right. Ms. Tucson?
Okay, thank you, Judge. So I have a address for you in the system in Stockbridge. Is that an accurate address?
Yes, ma'am. Jodico Station Circle. 304 Jodico Station Circle East.
Okay, and is that still Fulton County?
That's Henry County.
Okay, since they sent it back to Fulton, you'll have to report to Fulton, and then they're going to transfer it.
Okay.
Back over to. Do you know where probation is?
Yes, ma'am.
Fulton.
Yes, ma'am.
276 Memorial Drive.
Yes, ma'am.
Okay, you're going to want to report there within 48 hours of you being released.
Okay.
And do you have a phone number at the moment?
No, ma'am, I don't.
Okay. And failure to report after you're released from custody will result in a warrant.
Okay.
And once you report, they'll go over this case and transfer your case back over to Henry County while you'll be reporting.
Okay.
Do you need my number? Just I'll put my number on here just in case.
Thank you.
Uh-huh. There you go. And this is yours too. Yeah. I think so. you have any questions?
Can I, one more question. Is there, will I have to pay any fees or fines for the traffic tickets, like the insurance? Is there fines involved with that?
So, I'm not assessing any. So no, through this sentence, there may be some that occur by operation of law, and DMV could tell you about that.
Okay.
If we were in traffic court, that prosecutor would know off the top of her head, it's $375 and would request it. But I am fine that she doesn't hear, because you have more important things to focus on.
No, great. Yeah, I just didn't know if that was, I didn't know.
But I don't have the authority to waive a statutory fine. If you're on your 8th driving with no insurance, not that you were driving, it sounds like the car was parked, but either way, operating a vehicle with no insurance, it may be statutorily, you got to pay $500. I don't know. I'm not assessing any. So it would only be what DMV says you have to do. Okay.
Okay, cool.
Any other questions?
All right. Good luck.
Okay.
All right,
Good
thanks.
luck to you.
So Mr. Smith is our last. I've got about 20 minutes before I need to go. Should we try to do Mr. Smith now, or do you want to do Mr. Smith before the Adkins hearing?
Feeling ambitious, Judge. Let's try to do him now.
You've already talked to him?
I have not.
Oh, sure.
Very Yeah, let's just pop back in.
So they require you, because it's not a year, you have to say 12 months. Like his sentence looks funny.
I know it does.
But that's the right format.
I'm almost positive.
Okay.
I'm afraid if I say 4 years, they're gonna say,
But they're not going to require him to be on misdemeanor probation. It'll all be felony probation. He'll just have 2 years and 12 months of,
yeah.
Okay.
That's what I'm thinking of saying.
okay. I'm fine with it. I mean, if that gets us through the hoop,
As soon as I send it over there another year, they'll say that's 12 months.
right? You can't have a year on a misdemeanor. Let's do good, please.
He's excited to get a plea on him.
Yep. That was a tiger move. That was his thing.
He's with this Carnival, Church Carnival.
I think so. Yeah. Which was, I mean, he has managed to stay there because that was us, then Tucson, and then Carnesdale.
His caseload's probably,
He's like the Ellerby of, yeah.
I would be looking forward to going.
Yep. Little change of pace. Really? All right, then.
Excited about it.
Is that cool? Okay. Join him in now. Yeah. Just because I. No, right here.
Thank you.
Mhm.
All right, let's turn to Mr. Smith's case. Hello, Mr. Smith.
Good day, sir.
I'm Judge McBurney. It's nice to meet you. You have two cases. One is on the calendar, but I thought we would try to deal with both. I learned from Ms. Tucson. I'll give you the other case number as well. And I don't know that there's a warrant, probation warrant in that one, but there's about the same amount of probation remaining. On our calendar is 11 SC 102477, Mr. Smith's case. There's also a 10 SC 94516. And in both of these, there's about 10 years probation remaining. Mr. Smith got long sentences. And I don't want us to get sidetracked by the 10 SC. I just don't want Mr. Smith to get drawn back into court because we didn't address the 10 SC case. The warrant that I have is in the 11 SC case, and I signed it almost a year ago. Day after tomorrow, it'll be a 1-year-old warrant. The allegation in the warrant is that Mr. Smith violated his probation in the 11 SC case by, in May of 2018, committing a new offense of burglary in the second degree in DeKalb. And he was arrested in February of last year. And at the time of this warrant, which was June of last year, Mr. Smith was in the DeKalb County Jail. As best I can read this warrant, that all relates to the same thing, that there was an incident in May of 2018 for which Mr. Smith somehow was not arrested until February of 2021, and was in the DeKalb County Jail. Now he's in our jail, and we need to work through whether there are any consequences for Mr. Smith for having been arrested in DeKalb County. It sounds like in connection with an alleged second degree burglary. So, Ms. Wood, is Mr. Smith admitting to these allegations that he was arrested in DeKalb for this incident?
Yes, Judge.
Do you know if that has been addressed in DeKalb County?
Can I speak, sir?
If Ms. Wood says you can, that's fine.
Judge, he has indicated to me that he was out on a signature bond. They let him out on a signature bond to come here to resolve this. So I think that's what he wanted
I
to
have
share.
not been convicted on the charge, so I haven't been indicted.
Okay, so you've been arrested for an alleged second degree burglary in DeKalb.
Yes, sir.
That's it.
That's it.
Okay, so then let's confine it to that. Is Mr. Smith admitting, for the purposes of our proceedings here, that he was arrested in DeKalb for second degree burglary?
Yes, Judge.
Okay, and what is the defense recommending ought to happen to Mr. Smith?
Judge, he is asking to be revoked for the 30 days that he has spent here. He was brought over here May 9th of this year. So he's been here exactly 30 days. And he also wants to let the court know that he's been in continuous custody in DeKalb since February 24th, 2021. And so over a year on this whole incident.
So the signature bond wasn't a release to the street, it was released to the custody of Fulton County.
And I can get released if you release me.
If I revoke Mr. Smith for some period that ends soon, Mr. Smith will walk out of the Fulton County Jail, or he will be transported back to DeKalb?
Do you know?
I'm going out Fulton County, sir.
Okay. Do you have a place to live?
Yes, sir.
Where's that?
1604 Athens Avenue.
Oh, where you were. We've got that right here. What's there?
Grandmother's address
Okay.
all my life.
And grandmother will let you come back.
Yes, sir.
Okay. How is grandmother's health?
It's deteriorating, sir.
Who else lives there?
Derek White,
Who's that?
brother.
Your brother, your grandmother, and you would share that address.
Yes, sir.
Okay. You have been in custody now for over a year.
Yes, sir.
Any reason to believe your grandmother and your brother still live at that address?
Yes, sir.
Because,
I have people to go by there and check on them.
so you've received good word that your grandmother and your brother are still there
Thus far.
thus far. Okay. All right. So revoking 30 days, revoking 90 days, revoking 180 days, all as long as it's credit for time served, since the DeKalb arrest would have the same net effect.
Yes, Judge.
Got it. Okay. Any idea why Mr. Smith's arrest was almost 3 years after the alleged incident?
No.
So the time that the burglary is supposed to happen? No, none that I can think of.
No, Your Honor.
Okay. All right. Ms. Charles, your thoughts about what to do with Mr. Smith's situation?
Yeah, when I initially looked at that, I thought to ask to revoke a year and commit to term served since it's being continuous custody. And so that would be my recommendation, given that he has a special probation.
Okay.
About to fall out of chair.
All right. Ms. Tucson, am I correct in recalling what you shared with me that Mr. Smith has, give or take, about 10 years remaining on both the 11 SC case and the 10 SC case?
Yes, Judge, on the 10 SC, 9 years, 9 months, 1 day. On the 11 SC, 10 years, 2 months, 11 days.
Okay. And are you able to tell what the charges are in the 10 SC case?
Yes.
The 11 SC is a burglary. A few other charges.
On the 10 SC, death by receiving.
Okay. Do you have any convictions for Mr. Smith that are more recent than the 11 SC?
I do not.
All right. Well, you would know, Mr. Smith. Don't sound relieved.
Sure.
You would know. All right. Let me check with one other source. Ms. Jackson, how many cycles do you have for Mr. Smith? And do you have anything that is more recent than the 11 SC conviction?
Okay, the defendant has 38 cycles. The only most recent one I see was a 2013 felony conviction for theft by receiving stolen property.
Is that out of Fulton County?
It appeared to be out of Fulton County.
Okay, but that's still from 9 years ago.
Yes, Your Honor.
Okay, got it.
Okay.
Thank you. So, Mr. Smith, these are old cases. What have you been up to since then? You've been working, or what do you do to fill your days?
Working off and on at the used car lot.
Whose used car lot?
It's a friend of mine I went to school with. He just got licensed to buy and sell cars.
Okay, and what do you do for him?
Just detailing.
Detailing? Okay. And when you say went to school, high school, college?
High school.
High school, where'd you go to high school?
Carver High.
Carver High. Do you have kids?
No, sir.
What are you gonna do when you get out besides go home and hug your grandma?
Same thing. I'm going back to him.
To that used car lot?
Yes, sir.
Okay. All right. Well, based on your admission of having been arrested for a second-degree burglary in DeKalb, which remains unindicted, I find that you have violated the terms and conditions of your probation. I'm going to revoke 6 months of your probation. You will get credit for you'll get credit for the time you've been in dating from your arrest on February 24th of 2021. I think I'm gonna revoke 9 months because that'll get your 10 SC case to about 9 years remaining. So I'll revoke 9 months, but you'll get credit from February 24th, 2021. That's more than 9 months ago. So you ought to be released in the next day or so. If we get to.
Thank you.
It will, okay. If you want to be grateful, don't get arrested anymore. Work at this used car lot and take care of your grandmother and that kind of stuff. Watch Braves games. But you'll get credit for that time, so you ought to be released in the next day or so. If it gets to be Thursday, Friday, you're still in jail, you need to reach out to Ms. Wood so she can reach out to my office and we can reach out to the sheriff to say, why is Mr. Smith still in? He should be out by now and we'll take care of it. I am reinstating the balance of your probation. So you've still got a bunch of probation left. I will tell you that probation can become non-reporting, and in fact, it can become not probation anymore if you, for a few years, can stay out of trouble. So there's an incentive. In fact, it's called behavioral incentive dates to not be a pain for probation. And they'll say, you know, why don't we stop supervising Mr. Smith? And then they'll reach the point, why don't we close this case out? You've got lots and lots of probation left, and you can make that shrink down to just a couple of years if probation can go smoothly for a few years. Ms. Wood, do you waive any due process notice rights that Mr. Smith would have in connection with 10 SC 94516 so that I can do a revocation in that case as well? And there's not going to be a surprise warrant flowing from the DeKalb situation.
Yes, Judge, we waive.
Okay, so in both those cases, 11 SC 102477 and 10 SC 94516, I'm revoking 9 months, reinstating the balance, and continuing you on probation. I guess that's saying the same thing. You'll get credit for time served from February 24th, 2021. Officer, Ms. Tucson may have a few questions for you and may be giving you some reporting instructions. So stay right where you are, and she's going to take over.
Thank you, sir.
You're welcome.
Okay, Mr. Smith. The address that I have on file is on Athens Avenue Southwest. Is that still accurate?
Yes, ma'am.
And is your phone number 404-755-3257?
Yes, ma'am.
Okay, when you are released from custody, you will need to report. Looks like you have an Officer Davis. There will be a case note in here in regards to this revocation. And you'll need to report to the office within 48 hours of your release.
Yes, ma'am.
And you know where it's located, correct? On 276 Memorial Drive?
Yes, ma'am.
Okay.
Okay.
You can write on the back of that.
Okay.
Thank you.
Is that it?
Believe so. Thank
Okay.
you, Judge.
You're very welcome. Thank you all for the pleas and the work. We're going to reconvene at 1:30. Ms. Jackson and Ms. Tucson, you're welcome to attend, but it's a motions hearing. It's part 2 of an immunity hearing. So it's just going to be evidence. There won't be any disposition. So your attendance is not required. We'll leave the Zoom up and we'll just reconvene at 1:30. We'll have Ms. Charles and Ms. Feely and go from there. Okay. Thanks, everyone. You're welcome.
Thank you.
Thank you. I can help. Oh, of course. So we know what did you say? 1:30. I don't know. Did you want to go downstairs to?
Yeah. Do you think I can eat in there? Or do you guys eat first?
Yes, just a sec.
I would say eat first.
Yeah, I would think
just because I haven't been,
Yeah, and in the courtroom, I don't want to like cause a
but I
problem.
haven't been down there since they were doing jury selection over in like, the auditorium when they first started back, and then they moved it over.
Yeah.
So yeah, I would just say just to be safe.
Yeah.
Judge, did you need this plea sheet for Mr. Prozo?
I do. Thank you.
May I, quick?
Yep. Thank you. You gonna be here this afternoon or just Miss Feely?
I will be here.
All right. And intern, do you support both people or just Ms. Wood?
Mostly Miss Wood, but I kind of help Miss Feely too.
All right, great.
So I will be here this afternoon.
Everyone is welcome to public proceedings. Yes, ma'am.
Okay. So back there.
Okay, I might go back there with you.
That's fine.
I also don't know, I imagine, do you think they'll take some kind of recess in the afternoon?
So bolstering would, it's not the order. I mean, it would be odd if.
I know it's.
Can't really bolster in advance. So let's say you've got, I'm blanking, Sanders, whatever the victim's last name, Mr. Sanders.
Okay.
So he testifies.
It's in one.
If he gets beat up on cross.
But that's not the normal course.
He's confronted with conflicting, hey, didn't you say
Well,
this?
yes,
Then
so
you bring an
Jennifer
officer in.
said
That's not bolstering.
that,
It
gun
is
waivers used to go
providing
below
a
the
prior
officer
consistent
and
statement if he said
So-
something to the officer that's consistent. Bolstering, which is
No, I know, it's
improper,
a-
would be
Here, I'll
your
tell you
witness
if
says
something,
these
okay.
things that are helpful to you. They don't challenge that. And then you bring someone in who says, yeah, he said those things. So
Yeah,
you
that's
are
what Marilyn was texting me, that she was surprised they were doing
really
it.
bolstering is hearsay. It's basically a hearsay objection because if your witness was not impeached with something, he said, hey, Adkins had a gun and he shot me. And they don't say, wait, didn't you have a gun? No, I didn't have a gun. Didn't you tell the police I had a gun? I didn't tell the police I had a gun. You could bring an officer in and say, did he tell you he had a gun? No, he said he didn't have a gun. That's not bolstering. They tried to impeach him with a prior inconsistent statement. And he's saying, nope, what the guy told me was he didn't have a gun. If they didn't challenge Sanders about telling an officer about the gun, and you ask Mr. Sanders, what did you tell the officer? I told him I didn't have a gun. Okay, good for your case. I didn't have a gun. Then you bring the officer in. What did Mr. Sanders tell you? He told me he didn't have a gun. That's bolstering because that is a prior consistent statement, consistent with what Sanders said, but he wasn't challenged. And so you're basically bringing someone in to say, well, isn't Sanders a real truthful guy? And you want to do that, that's fine, but they could object and that would be hearsay. I would sustain it. They may say bolstering, but bolstering really isn't the legal objection. It would be, that's hearsay because you're asking an officer, what did Sanders say? But a prior consistent statement can come in if you are rehabilitating your witness.
And so if I have the officer testify first, I can't do that.
Right.
I've got the Sanders testify, see, this is an inconsistent thing in the officers.
You could do it, but you would have to say, Judge, I am forecasting that they're gonna try to impeach Sanders with a prior inconsistent statement, but you'd wanna, it's just cleaner to do it the other way around. If you think the officer is going to bolster, as in support what Sanders says, you have Sanders testify first, right? I gotta go. Sir. Oh, you cleaned it up. You got your Celtics stuff hanging in there? Okay, all right. Good enough.
So courtroom 8, Delta.
I need to run back down.
What?
I need to run back down. Just him. The officer's questions. I have his questions in my computer.
Okay.
I'm gonna sit with the officer's suite. I'm gonna keep the officer's suite. Chris just showed up. He called me 10 minutes ago. I'm here. Bro, you just text him. So he's like, yeah.
Where first up?
Wait first, I don't know, because the defendant, they're not put it. They don't put it on this.
No, but what I meant is there's not.
Nothing else, so once we come up with one discuss. So, because Robert came on, we're going down for just. Back to the office. Could just be. Foster love. I'm not. Finish what he did. You will get this. This one. Let me show you what the entire notes. And summarize the whole thing. I was gonna ask a question. If it's a different narrative in the script. I mean, I can have some more clarity on that, right?
You should see the notes.
I told him. So he was because he wasn't even subpoenaed. I just called him.
Yeah.
But I couldn't find
definitely
proof.
figure out who it's supervisor.
Telling you that's just what it is. Let me run back there and to Ron. Is the front row reserved?
I'm sorry, it's the front row reserved for attorneys, yes. I can get it from here.
And is it for per case, the Zoom information? Or is it just?
Per case?
Yeah.
What case is it?
It's Gary Atkins, A-D, as in David, K-I-N-S. His wife wants to be able to Zoom in. And can she just log in and then she'll just see it as a. Okay. Okay, let me copy it out. Let me fold it out. Oh, you don't need this back? Okay. I just want to make sure it's 9238-5307-013. And then I guess the pass is 282853.
I got a school of all, man. I'm
Order something.
That's what it is. I got 2 ideas. I got 5 minutes, sir. Okay, for the long show.
Yeah. Yeah, for sure. This year.
That's what the officers are.
No, just the.
Open order, nice seat.
We all right?
Yes. I didn't.
Okay. All right, Ms. Rivers, you ready? Great. Do you need to speak with Mr. Adkins before he's brought out? Or are you ready for him to come out?
I'm ready for him.
Great. If we could bring Mr. Adkins out, please. Okay, let's get started. This is case 21 SC 178589. It's State versus Gary Adkins. Hello, Mr. Adkins.
Hi, how are you?
Good to see you again. We've had a little delay, but we're picking back up where we left off. Mr. Adkins has, through counsel, filed an immunity motion. He is charged with aggravated battery and aggravated assault that relates to a shooting that happened on or about May 1, May 2 of last year. The alleged victim in this case is Mr. Sanders. We started the immunity hearing in February of this year, and I received evidence from Ms. Adkins, who is the wife of Mr. Adkins and the sister of Mr. Sanders, the person who was shot. Ms. Adkins testified, was cross-examined. I'm just seeing from my notes here how far we got. It looks like it was all Ms. Adkins. That's as far as we got. It was Sham Patel was the lawyer then representing Mr. Adkins who filed the immunity motion, and she represented Mr. Adkins at part one of the immunity hearing. We have Ms. Feely now, who is ably stepping in for Ms. Patel, and let Ms. Nelson know when she, Ms. Feely, was sufficiently connected with Mr. Adkins' case that she felt comfortable moving forward with part two of the immunity hearing. We have Ms. Charles for the state and Mr. Malkin, her supervisor, here as well. Hello, sir. Good to see you. Ms. Charles handled the first part of the immunity hearing, and I think we're in a position to pick up where we left off. I've reviewed my notes, so I'm back up to speed with the general setting that, at least according to Ms. Adkins, so this is just based on her testimony, I'm not making any factual findings at this point. The three, Ms. Adkins, Mr. Adkins, and Mr. Sanders had been all in a car together, and there was some tension about Mr. Sanders maybe getting lost, Mr. Sanders maybe having smoked marijuana in the car, which got Mr. Adkins frustrated because his kids might be breathing that secondhand smoke. And eventually words turned to some shoving. outside a house. And according to Ms. Adkins, when her brother started to pull away, she was encouraging him to leave so that her husband and her brother could be apart, given that tempers were hot. The way in which Mr. Sanders left, it dragged Ms. Adkins along a bit, and Mr. Adkins pounded on the car. I think it's Ms. Adkins' mother's car, not Mr. Sanders' car, but regardless, that got Mr. Sanders out. They were sort of chest to chest. And then all of a sudden, Mr. Adkins shoots Mr. Sanders. Turns out it was in the leg. Mr. Sanders was able to drive away a bit, but couldn't go further. Ms. Adkins got to him, meaning her brother, where the car had stopped. The police arrived, and she gave a statement to the police. I think we completed Ms. Adkins's testimony. I don't want to preclude either side from recalling her, but I think that was the natural break point. And then we looked at the clock and said, boy, we didn't allot enough time for us to get through the whole immunity hearing. Do you know, Ms. Feely, is there a plan to recall Ms. Adkins, or your review is that you got the testimony you were going to get?
I think we have what we need, Your Honor. I have been in touch with her. She's watching on YouTube, so if we were to need to recall her, I could get her the Zoom link, but I don't anticipate having to do that.
Okay. All right. Your sense as well, Ms. Charles, no need, you wouldn't be recalling Ms. Adkins. I guess anyone might, based on what another witness says. Like, wait a minute, that's completely inconsistent. Let's get Ms. Adkins back on the stand.
At this point, I don't anticipate recording Ms. Atkins.
Okay, great. Then who are we calling next?
Well, Your Honor, as a preliminary matter, I do understand that Ms. Charles has several witnesses in the hallway. We have Ms. Atkins here, I thought in support only, but depending on, as the court is well aware, the only people on scene to witness anything that happened were Mr. Sanders, Ms. Adkins, and Mr. Atkins. So if the state's other witnesses are going to talk about prior inconsistent statements or omission of statements or something like that, we would actually probably need Ms. Atkins to, Ms. Jamison, I'm sorry, to testify as well.
Okay.
Yes,
And
what I'm asking is, do I need to have her leave the courtroom at this time, or can we get some visibility on?
well, I'm confused first by who we're talking about. Ms. Jamison?
Jamison is Mr. Atkins' mom.
Okay. Not the mother of Mr. Sanders or Ms. Adkins, but Mr. Adkins's mother. And her connection to this case is simply, my son's a good guy, I wouldn't shoot someone without provocation? Or because the mom, I thought the mother who was connected to this, it was someone's birthday. It's also my birthday, same day. But it was, if I go back to my notes here. Yeah, so I thought it was Ms. Adkins' mother's birthday, the night all this went down. And so that would be Mr. Sanders' mother's birthday as well. I don't recall there being a whole lot to do with, and the last name was Jamison?
Jamison-Atkins.
Jamison Adkins, got it. So you can call anyone you want. The only reason why I'm probing about the connection would be, it may not matter if Ms. Jamison Adkins hears other testimony, because it's not going to influence hers. I'm not aware that she was present for Mr. Sanders' encounter with law enforcement when they rendered aid, and then he was whisked off to the hospital. So
my concern is I do see Miss Sanders here also, and if she's just here in support capacity, that is one thing, but if she is going to be called as a witness, I think I would need more information to know whether I need to sequester Miss Jamison Atkins.
okay, why don't you, in a thumbnail sketch, tell me what Ms. Jamison Adkins would have to say about the facts of this case?
Well, and this is, I guess Ms. Charles and I can discuss whether Ms. Sanders is going to be called as a witness, as she was not there either. But if she is coming to testify to rebut or say that Angel, who's already testified, Angel Atkins, said something inconsistent to her, then we would need to call Ms. Jamison Atkins to,
Because of things that either Angel Adkins or your client said to Ms. Jamison Adkins.
right, and I think it's a lot more straightforward to just stick to the people who are on the scene testifying, but if we are going to go back and forth with prior statements, then that would be my only concern.
Got it. Okay. Ms. Charles, tell me, are you planning on calling Ms. Sanders?
I have your.
You are?
Yes, sir.
Okay. All right. Then why don't we see how things unfold? But folks who might be testifying probably shouldn't be in court, other than, of course, your client. And if there's a lead investigator, that person could be here. Angel Adkins has already testified, so in theory, she can continue to watch on YouTube unless there is a concern from either side that that would be inconsistent with the rule of sequestration. But otherwise, I think you're going to call whoever you're going to call next. Everyone else needs to be outside the courtroom. If hypothetically, if your next witness is Mr. Adkins, Mr. Sanders needs to be outside, his mother needs to be outside, and Mr. Adkins' mother needs to be outside. Is that your next witness?
No, Your Honor, at this time, the defense rests.
Oh,
for
okay.
purposes of this hearing.
Got it. All right, then let's pivot to the state.
Your Honor, before we call our next witness, the state would like to move for a directed verdict because at this point.
Can you, thank you. It's all right.
Based on the testimony we have heard so far, the defense has not met its burden by preponderance of the evidence to show that Mr. Atkins' use of force on the day in question, May 2nd, meets the elements that he needs to have met to prove that the shooting was justified. Nothing in Ms. Atkins' statements corroborates Mr. Atkins having a reasonable belief that a threat of force was necessary to defend himself and Ms. Atkins against Mr. Sanders' imminent use of unlawful force. Nothing in Ms. Atkins' statements so far justifies Mr. Atkins having a reasonable belief that Mr. Sanders' actions of reversing out of the driveway that night was intended or likely to cause death or great bodily harm. And Mr. Atkins' use of force would only be reasonable if that force was necessary when he shot Mr. Atkins to prevent death and or bodily harm to himself or Ms. Atkins. And what we've heard so far, Your Honor, does not rise to that standard, and that we would just move for a directed verdict.
Okay. Yeah. So I don't know that directed verdict is the precise term, but basically you're arguing now, Judge, would you please rule on what you've heard, because the defense has had an opportunity to present its case, and you're basically asking, based on what you've heard, do you think they've met their burden? And if I find they haven't, we're done, because they had a chance to meet their burden. If not, because it's not a verdict I'd be entering, it would just be, I'd be denying the motion, but I understand your request. Let me hear a little bit from Ms. Feely, and then we'll figure out what we're going to do next. So Ms. Feely, my recollection of Ms. Atkins's testimony is that she did not see her brother with a gun. There may have been a perception that he was posing a threat. Mr. Sanders, was posing a threat to his sister as he backed out and she was being dragged along. That had stopped when your client slapped the hood of the car. Car stopped, Ms. Adkins now out of harm's way in the sense of, maybe being assaulted by the vehicle. Mr. Sanders gets out of the vehicle, and now we've got the chest to chest, more words, a continuation basically of the dispute that Mr. Adkins and Mr. Sanders had been having. And Ms. Adkins described her brother as being verbally aggressive towards Mr. Adkins, some language we probably wouldn't see on primetime television, coming from Mr. Sanders. I'm going to get you, I'm going to mess you up, etc. Ms. Adkins trying to get her brother to leave, and then her testimony was all of a sudden her husband shoots her brother in the leg. And then her brother drives away. So just following up on Ms. Charles's argument, what is it that you think in the record so far, which could be the whole record if the state chooses not to call anyone, rises to the level of sufficiently justifying the use of deadly force on Mr. Sanders.
Yes, Your Honor. So reasonable belief, the testimony that we've heard so far, first we heard about the threats and the intimidation. She testified to Mr. Sanders following Mr. Atkins around the car, doing the tough guy stuff, making those bodily threats with the fist balled up. And then she also testified about Mr. Sanders getting physical with her. I don't know if the court caught that Mr. Sanders was pushing her hand out of the way. She was pushing her. He was moving her, which, but then, Your Honor, the most important thing is the dragging with the and the timeline with which that happened. So she testified that I was with the car when he pulled out. I was not standing in the same spot. I went a little distance. He pulled out real quick. I was off my feet. I was jerked. She further testified, Your Honor, that I was definitely scared, and it was 3 to 4 seconds between that happening and then the shot being fired.
So if she were the one who shot Mr. Sanders, the things you're talking about might have more resonance because she's the one who was scared, describing I felt scared, saying I got lifted up, etc. But then that ended. Mr. Sanders gets out of the car, and then it's Mr. Sanders and your client, and not Ms. Adkins anymore.
Sure. So 2 things. One, he also has right to defend a third party, which he and his pregnant wife is doing here. And also, I would argue that the threat had not ended. It was just mere seconds. And also, Your Honor, the statute reads that it can be to prevent death or injury or a felony. So aggravated assault is a felony. And as this court knows, certainly cars are named in indictments all the time as a vehicle with which to commit an aggravated assault. So we could also continue on under that theory as well. And using a car to drag someone certainly could be categorized as an aggravated assault.
True. I guess then help me work through the completed act, because if we were to characterize what Mr. Sanders did to his sister as an aggravated assault, which the state has clearly charged people for doing something like that before, so it's not out of the realm. But that was completed. Mr. Sanders gets out of the car. He's not driving the car anymore. There's no assault with the vehicle. That, of course, is not against Mr. Adkins. It's against his wife. But Mr. Adkins does have a right to defend others, to include his pregnant wife. But that aggravated assault, if it were one, had come to a close. So what, I appreciate, I'm not suggesting it was 20 minutes later. They're close, and maybe that's your argument, it's just they're so close in time. But chronologically, it would be incorrect to say the shooting ended the aggravated assault against Ms. Adkins. The hand on the hood of the car may have, but Mr. Adkins isn't charged with criminal damage to property. That may have been what stopped the aggravated assault, but it came to a close and we moved to the next chapter. And you may say, no, not even next chapter, it's the next page. Mr. Sanders gets out of the car, more words from both Mr. Adkins and Mr. Sanders, chest to chest kind of thing. And he's shaking his head. I'm not even what happened, but he can testify if he wants to testify. Ultimately, your client shoots this guy in the leg, not while he's still driving the car, not while he's still dragging Ms. Adkins, but after he got out of the car, and it's now Mr. Adkins and Mr. Sanders. So how does the shooting constitute preventing the felony that already happened?
So given that she testified it was 3 to 4 seconds, so it wasn't like a confrontation where they went back and forth, but the dragging of the car happened, the car stopped Mr. Sanders. I don't know that you would consider exiting the vehicle, but I think the testimony was that he stood up kind of out of the car where Mr. Atkins was. And as I believe the court is aware, he then drove off. So that could very well have been a continuing assault with the motor vehicle. Luckily, he struck other things and not people, but so I would argue that it's a one continuous event.
Okay. All right. Yes, ma'am.
May I counter?
Yes, as the movant, you can have the last word.
Thank you, Your Honor. Your Honor, Ms. Feely's characterization of the facts is erroneous. Mr. Sanders drove off after he was shot. He didn't drive off before. As Your Honor correctly stated, it was the banging on the hood which stopped the car. Mr. Sanders exited the car and then he was shot once in the thigh. Ms. Atkins clearly stated that she was jerked, but it was only for 2 or 3 seconds. There wasn't, as the statute requires, a risk of great bodily harm. Her testimony was that she was dragged a little bit off her feet, and then her words in the transcript was she immediately regained her footing. Therefore, she was not at risk of great bodily harm. The shooting, when it happened at the end of the alleged assault on Ms. Atkins. Therefore, the shooting was not to prevent the commission of a forcible felony, as Ms. Feely is trying to characterize Mr. Sanders driving off after he was shot. It is very speculative for a defendant to suggest that Mr. Sanders was imminently about to commit a forcible felony when the slap on the car again stopped it. So the imminence had ended, the threat of any harm to Ms. Atkins or her unborn child had ended. At this point, it is Mr. Atkins acting out of anger and being the aggressor and shooting Mr. Sanders in the leg without justification.
So just so we don't have to have a sir rebuttal, I didn't hear Ms. Feely say that Mr. Sanders drove off at some other time. What I heard her say is he still was able to operate this car after he got shot because he then drove off, which is what I think the record shows. And then he stops the car. I think it's Cheshire Bridge. The doors open and the police arrive. So I think we're talking about the same set of facts. Ms. Adkins, to me, a critical piece of her testimony was this all happened so quickly. So it's not, I didn't mean to make it sound like there was 5 minutes between each thing. Ms. Adkins is dragged a little bit, then everyone pauses to see what's going on. Mr. Adkins hits the car, everyone pauses. It is all very quick and sudden. And Mr. Sanders does emerge from the car after Mr. Adkins is able to convince him to stop it by hitting the hood. And that's when Mr. Sanders and Mr. Adkins are once again face to face. I am at this time going to deny your motion and ask that you present whatever you want to present. You may choose to present nothing now that you've heard the defense rest. And then I would need to decide based on I don't have the transcript in front of me, so I'm relying more on arguments that you all are making, and I have reviewed it. But just based on what we've got right here, rather than say, well, why don't we reconvene in a couple of weeks after I could reread the transcript and decide it, I'm gonna ask that you present what you want to present in terms of witnesses. But I'll keep in mind your motion, and I may say after you call a particular witness, I don't need to hear anything more from the state. Having heard from Ms. Adkins and witness X or X and Y, then I'll ask the defense if they want to put anything else on. But if I tell you I've heard enough, that means that I've found that in conjunction with Ms. Adkins' testimony, what you've presented gets you to where you think you are already. Okay. So with that, who are you going to call?
So we'll call Tyrone Sanders instead.
All right.
Case where our affirms the testimony that gives the court the truth, the whole truth, and nothing but the truth. So there we go. State your name for the court, please.
Before you do anything more, I need you to move that microphone around so it is facing towards you. You can put your hand down now. And if you're comfortable with it, Mr. Sanders, if you don't mind removing your mask, we'll be able to hear you a lot better. but I need to make sure you are, and your chair does not have wheels, so give it a big heave, but you need to get closer to the microphone so that everyone can hear you, okay? Now, Deputy asks you to spell your name for the record, please.
TEROHN SANDERS.
Sorry.
TEROHN Teron SANDERS Sanders.
And Your Honor, if I may interrupt, I may have misunderstood, but I thought Ms. Charles was intending to call Ms. Sanders, so we would just invoke the rule.
Sure. If you do intend to call Ms. Sanders will need to wait outside. Similarly, if you intend to call Ms. Jamison Adkins, she'll need to wait outside. You guys probably should wait outside in different places.
The officers as well.
I wasn't sure if you're planning on calling all three of them. They should be outside.
Should be different pieces. We'll see how far we get.
Okay. All right, and Mr. Sanders, I'm just going to remind you, you got to talk like you're outdoors at a concert and folks can't hear you well, so that Ms. Charles needs to hear you. And we've got a question from the deputy.
I apologize, Your Honor. The wrong turn is on outside.
Thank you. That's not an apology. That's great. Let me, the audio is playing or there's no audio. So it's okay for people to see. If you're going to suddenly use a giant demonstrative that says the state's secret to the case is, let me know and we'll kill the video, but it's not audio. All right.
Good afternoon, Mr. Sanders.
Good afternoon.
How are you?
I'm good.
Thank you for being here today. We've already stated your full name for the record, so we'll just direct you directly to the time of the incident, which happened in a second.
Yes.
At the time of the incident, were you employed?
Yes.
Where were you employed?
A restaurant called Gyukaku, GYU-KAKU. It's a Japanese barbecue grill in Atlantic Station.
What did you do there?
I was a cook.
How long have you worked at?
In probably like 2 years.
What other hours did you work there?
My hours were flexible, but I mostly work like night shift. Like I'll go in 4:30 to 12.
How do you know when you get to and from work?
I was at the time I was sharing a car with my mom.
Did you live with your mom as well?
Yes.
On May 2nd, what time did you get to work?
About 4:30, 5 o'clock.
What time did you leave work?
About 12. Yeah, about 12 or a little after.
Until midnight,
Yes.
And on that night, how did you get from work to home?
My mom dropped me off at work. It was her birthday that day. She dropped me off at work. And when I got picked up, I was supposed to get picked up by my sister and her husband. And I was supposed to return the car to my mother after they take themselves home.
So they were going to pick you up in your mom's car.
Yes.
On the way home, did anything happen in the car?
Yes, we got into an argument on the way home, like probably like 5 minutes after they picked me up. I gave them like a small direction on how to get around Atlantic Station. It was a small detour from the way that they wanted to go.
Who was driving?
Mr. Atkins was driving.
Where are you sitting in the front of the car?
In the back seat.
Where was Miss Atkins sitting?
In driver's seat.
Miss Atkins.
Oh, in the passenger seat.
And how long did that initial altercation between yourself and Mr. Atkins last for?
Probably about 10 minutes maybe.
Did it escalate maybe?
No, it was just verbal, and then he said to me, I have something to say to you when we get there, or something like that. In the nature of like he wanted to fight. That's his tone. That he wanted to, we were going to fight when we got there.
And I'm sorry to interrupt, but there you were going is actually your sister's house.
Yes.
Because Mr. Adkins and your sister, had to get home because everyone's sharing this car.
Yes.
And then you would drive your mother's car home from your sister's house to your mother's house, which is also your house.
Yes.
Okay.
What time did you estimate you arrived at your sister's house?
It could have been about 12:30, maybe. About 12:30.
Was it like, what was the conditions like when you got there as far as lighting?
It was dark.
Was that-
It was dark.
Could you still see clearly?
Yes.
Was there an outside light?
Street light. Yeah, there was a street light.
At this point, I'd like to permission to share my screen.
Sure.
Mr. Atkins, what do you currently see on the screen before you?
I see my sister's house.
Your Honor, I'll be using a series of pictures for the purposes of mutual aid to have this representative assessment.
Okay. Is your sister's house the house that's on my left, the beige one, or the brick one to the right?
Sorry, something on the
That's
screen.
the big board.
Well, that's a touchscreen though, so he could, it is. It is. So if you touch the, well, first of all, say, got it. And then touch the lower left-hand corner of the screen, way down there, tap it. And then there should be a pencil, that little circle, the pencil, tap that. All right, now circle for me, please, the house that is your sister's. Is it on the big screen? Big red circle? Right.
So once you get to your sister's house, circle on the screen where the car, where you sort of got out of the car.
Yeah. This is where we got out the car.
I can't hear you.
This is where we got out the car.
Did you enter the house?
No, I didn't.
Who entered the house?
When we got out the car, me and Mr. Atkins, that's when we started to talk. Well, when we first got out, I was asking him, so what are we doing? Because I'm thinking we're getting ready to fight. And that's when we, like a physical fight. I thought we was going to have a physical fight from the way the conversation was in the car on the way there.
Had you and Mr. Adkins ever had a physical fight before?
No.
Why this time? You'd met him before. This wasn't your first time spending time with Mr. Adkins.
No.
How long had he been married to your sister? Ballpark. 1 month, 1 year, a decade?
A couple of years, I believe.
So you'd spent lots of time with Mr. Adkins.
Yeah.
What was it about this drive from your work to their house that made you think, for the first time ever, I'm gonna be in a fight with this guy?
The words that was being exchanged, his tone, like how the aggression.
Specifically, Mr. Sanders, what was the fight about?
It was really out of nothing. It started from he got overly upset about going around around Atlantic Station instead of going the way his GPS wanted him to go.
What did it change to?
Like he started to disrespect me. Like speak to me as if I was a child, like I wasn't a grown man. He was disrespecting me like that.
Was he telling you to do anything or giving you instructions while you were in the car or in the driveway?
In the driveway, no. Well, in the driveway, when we got to the driveway, he told me, because I thought we was getting ready to fight. So he was saying, I just wanted to talk to you. He says, so my sister is telling us to go ahead. And he was like, no. He was like, no, we're good. Tell your sister that we're good. We're just going to talk.
What were you going to talk about?
What he came up with was that he asked me, do I smoke? And I said, yes. He asked me, do I smoke at home in my room? I said, yes.
Did you smoke cigarettes or something else?
At the time, it was marijuana.
Why was that a cause of concern for you?
I have no, because the kids was there. The kids was over because it was my mom's birthday. So they were in the house.
Want you to smoke in the house, kids.
Yeah.
That bothered you?
No, what bothered me was that he could have he started an argument and he could have said that on the way there. He could have sent it in a text instead of making like a big scene and an argument for nothing just to say those words.
So at this point, the three of you are in the driveway. What happens next?
Well, my sister goes in the house when we were talking, when me and him was talking, my sister is in the house. And then when he says what he has to say and I'm mad, I'm saying you could have just said this in a text or on the way here. You did all this for what? So when I'm loud, so my sister hears me, she comes back outside and she's trying to de-escalate it. So
Okay, so now you're back outside. Where are you on the driveway?
we're like right here. We were standing behind the car at this time.
So these are halfway
Yeah.
driveway?
Yeah, it's about halfway.
So closer to the tree, not the mailbox, right?
Yeah.
You can make the circles go away too. If you push in that corner again, the little bar comes up. I think there's something that looks like an eraser. And if you tap on the eraser, it makes stuff you drew go away so that it clears the screen. Is that anything like that happening?
That's the circle on the screen where you were at the time.
Yes.
Can you show me, you get rid of the circle, 3 circles and show where each of you were at the time?
Well, we're all standing like in the same spot.
Who's closest to you at the time?
Probably like he's on one side, my sister is on the other side of me. Like it's about the same distance.
At any point did Mr. Atkins go into the house?
He goes in the house when I'm leaving. I'm looking through my book bag in the back seat looking for my phone. And then that's when I ask my sister to call my phone and she goes in the house after him.
Where on the driveway is the car?
The car is probably like here. The car is about here.
And he goes into the house. So
Yeah, he goes into the house first.
So it's yourself and Miss Atkins outside.
Yes,
What
for a
did she
short
say?
period of time. At the time, she's not saying nothing. When I asked her to call my phone, she's not saying anything. She goes to go get her phone so she can call my phone.
So at this point, you're getting ready to leave, is that correct?
Yes.
Why didn't you leave immediately?
I didn't know exactly how to get home like by heart, so I had to look for my phone to GPS how to get home. So once I got into the car, I was actually putting in the address when they came back outside.
Were the windows open or closed at the time you came into them?
They were closed.
Was the door of the car open or closed?
Closed.
Once you got into the car, where was Miss Angel Atkins?
She was on the driver's side at the window.
How close to the car was she?
She was like right in front of the window. She was pretty close to the car.
Talking to you.
She was talking to me. She asked me, was I gonna smoke in the house when while the kids are there? I said to her, you're gonna ask me the same dumb question, and I rolled the window up.
Before we go any further, so did your sister actually go inside the house and get her phone and call your phone so you could find it?
No, I found my phone before she can call it.
Okay, so you found your phone eventually, not because she called it.
Yeah, I found it eventually.
Okay,
but
she did go inside. I'm sorry.
Did go inside.
Okay.
After you say to her, and you ask her the same question,
Mm.
what did you do next?
I rolled the window up, and that's when I pull off.
Where was Mr. Atkins Once you put the car in reverse.
He was on the passenger side, on the passenger window.
Was he saying anything to you?
Yes, he said something before she did. He asked me the same question. And I told him, I said, I'm going to do what I want. And I rolled the window up.
Where was Miss Atkins' hands as you put back?
Once I started to pull backwards, she tries to open the door and the door is locked and her hand slips off the door. Her hand slips off the door. She tries to open the door as I'm backing out.
How fast were you going as you backed?
Probably about 5 miles or less.
What happens as you're backing up?
Mr. Atkins bangs on the hood.
What do you do then?
I stopped the car.
When you stop the car, what did you do then?
When I stopped the car, after he bangs on the hood, he's walking around to the driver's side. So I open the door and I stand up.
Did you get all the way out of the car or were you partially in the car?
No, I got all the way out the car.
Did your sister ever talk to you about why she was trying to open your door as you were backing up?
No.
But while you were backing up, she was saying to you, don't go over there smoking.
Yeah, she asked me, was I going to smoke when I got in the house? That's what she asked me.
Christian tobacco.
Yeah.
Could you show us on that picture where you were standing? Once you opened the driver's side door, where were you standing? And where would be Mr. Atkins in relation to you?
I was standing like right here, and he probably was like this close.
So the door was not in between the two of you, is that correct?
No.
From the time he banged on the hood to the time he made it around to where you had to be standing, how much time had come?
It's like as soon as I opened the door, like we met up at the same time. It was like I stopped the car. He bangs the hood as he's walking around the car. So as soon as I opened the door, the car door, he's standing right in front of me.
Where's Miss Atkins at this time?
She's still standing in the same spot from when I initially backed out when she tried to open the door.
Was that close to the car or close to the house?
Closer to the house.
What does Mr. Atkins say to you?
He doesn't say anything. When I get out of the car, he shoots me.
When you get out of the car, do you say anything?
No.
When you get out of the car, do you have anything in your head?
No.
When you get out of the car, did you reach for anything from inside of the car?
No.
How many times were you shot?
I was grazed in my right and went in and out my left.
Say that again?
I was grazed in my right leg and went in and out my left leg.
So it went all the way through your left leg?
Yes.
Same bullet actually cut one leg and then went through the other one?
Yes.
Once you were shot, what did you do next?
I get back in the car and I back out.
Were you able to
Try
declare the driver immediately?
No, I hit the light pole that's right here.
And once you hit the light pole, what did you say to you next?
I kept going. I never stopped at the light pole.
Why didn't you stop? To just
I wanted to get away, get to safety.
Once you'd gotten away, what did you do next?
I looked at my phone. I saw my mom had just texted me, so I called my mom first. And then I told her what happened. I told her that I just got shot. I told her that he just shot me. And she tells me to call 911.
Where did you stop after you talked to your mom?
It was like about right here.
What's the name of the street that you stopped at?
Cheshire Bridge Road.
From your sister's house to Cheshire Bridge Road, what's the distance like? How is it?
2 minutes. It's just right around the corner.
Once you stopped, you called 911.
Yeah.
Did you have conversation with Miss Atkins? When did you next see Miss Atkins?
I had flagged someone down and it was like a couple of guys out there with me waiting. And then she runs around probably like about 10 minutes after that. After I leave the scene, she comes around about 10 minutes after. and she runs to me.
What does she say to you when she runs to you?
She asks me, I believe she asked me, am I all right, or something like that. She asked me, was I gonna tell the cops what happened? And then after
To
that,
go further, I have a couple questions. Your sister showed up on foot? Like she had basically run or walked from her place to where you were?
yes.
And you may have answered this, I was taking notes. Why did you stop where you stopped?
To get help. Well, I didn't, when I called 911, I didn't know where I was. I didn't know the name of the street. So I had to flex one down to find out where I was.
Okay, but you chose to stop. It wasn't that, oh, I passed out. It was like, I'm now away from my sister's house and now I'm gonna get help.
Yeah, I chose to stop.
Okay.
Before we move on, just to clarify, about quickly, Mrs. Sanders, when you were at the house, at any time did you ever have anything in your hand?
No.
And you testified, just to make sure I understood correctly, when he came to the doorway, he didn't say anything to you?
No. Yes.
After May 2nd, when was the next time you spoke with Ms. Atkins?
Objection and relevance.
Your Honor, in subsequent text messages which Ms. Atkins testified to, the initial, the first part of this motion, Mr. Atkins testified to certain conversations between himself and Mr. Sanders, which we would like Mr. Sanders to respond.
Okay. And presumably these text exchanges were about this situation and not, hey, what are you getting mom for her birthday?
That's correct.
Okay. So I'm gonna overrule for now, but we'll revisit. You can continue.
Mr. Sanders, when was the next time you spoke to your sister after that night?
Probably like it was the next day, I believe. She was on the phone with my mom, and I talked to her, and she was saying she was apologizing. She was saying something about he maybe thought that my hand was on the door.
Stop for a sec. You're relaying right now, Mr. Sanders, what your sister supposedly told your mother or what she told you?
My mother. That's what she told my mother. Well, she said the same thing to me, that maybe he thought that her hand was on the door.
Okay, but before you get into what she said to you, because we may end up going there, how do you know what your sister said to your mom? Because you could hear it, or because your mom said, here's what your sister told me?
No, I could hear it. My mom, when she had her on the phone call, it was on speaker, and my room door is open and my mom's room door is open. So I hear the whole conversation.
Okay, so you're actually hearing what your sister says. It's not that your mom is sharing with you, hey, here's what your sister just told me.
No, I'm hearing it.
Okay. And your objection is hearsay. How is it not hearsay what Ms. Adkins is saying?
Because Your Honor, he's testifying to what he personally observed and heard.
Right.
Personal recollection.
He heard her say, which would be hearsay, unless there's an exception. It's not hearsay or there's an exception, because he's offering an out-of-court statement, something Ms. Adkins, his sister, said. Maybe he's not offering for the truth of the matter asserted, or maybe there's an exception. So I can't say that it is or isn't hearsay, because you may have an argument that it's not structurally, it's hearsay. He is saying, I heard my sister say, hearsay. So you need to explain to me why it's okay for this witness to talk about what someone else said.
Because it goes later to what she says in the text messages and explains the possible motive for the conversation that she's having with Mr. Sanders.
The later conversation, the text exchange. Okay. I'm comfortable letting it in, given that I'm the fact finder as opposed to a jury, but I don't mean to preclude you from making other hearsay objections. It sounds like different witnesses, depending on how far we go today, will be saying, well, this is what someone said. could be prior consistent statement, prior inconsistent statement. That's going to be kind of woven together here.
Yes, Your Honor. The other problem with this procedurally is that it seems like impeachment. However, because this hearing, she's already testified. So proper impeachment would be to confront her with these statements and give her an opportunity to confirm or deny and explain and all that. And here it's just, this isn't proper impeachment. So we would object to all of this line of questioning.
Okay. I'm going to overrule that. We're in a slightly different dynamic. Because I understand how you're viewing it as potential impeachment. It also might be corroborative of things Ms. Adkins said on cross-examination. But then there was redirect where there were efforts made by your counterpart to, I don't know if impeach is the right word, but to challenge some of what was said on cross-examination. So I think both sides are entitled to rely on other statements that Ms. Adkins made that were consistent or inconsistent with things that came out during her, meaning Ms. Adkins's testimony. So I'm going to allow it for now, but I'll keep in mind your concern. Why don't you repeat your question so we regroup or something close to it?
Yes, Mr. Sanders, I was asking, what did you hear Ms. Sanders say about what happened the day before?
When you say Ms. Sanders, you mean Angel Adkins?
She had said something about, she was apologizing and she said that maybe he thought that her hand was on the door.
When you said he, who was she referring to?
Mr. Atkins.
You later had a text exchange with Ms. Atkins?
Yes.
Do you recall, what was the context of the text messages? What did you say to her while she said to you?
I can't remember exactly what I said in the text messages.
If I was to show you a copy of the messages that was shown to Ms. Atkins when she testified without pressure action?
Yes.
And these are texts, Ms. Charles, that you contend were exchanged between brother and sister.
Yes, sir. Yes.
If you're done with that, Matt, while he's reading that, can you either take that down or?
You can stop sharing for now.
Thanks.
In the text message you just read, where did Ms. Atkins make a reference to the fight or the incident of May 2nd?
Make sure you're talking into the microphone when you do answer. You're welcome to keep reading that.
Can you repeat the question?
What did she say in those messages about the fight between herself and Mr. Atkins?
She says, well, she makes comments about I guess it was the bond hearing when they was saying his side of the story and when they said that I was drunk and trying to go to a party, and she said that she never said that.
How did you respond to that?
Well, she said more things. I responded to the part where she said that she called me Mr. Super Cooperative. She called me a rat.
Why would she
So
call you a rat?
I guess because I'm telling the truth.
Does she go on in the text messages, talk about her loyalty to her husband?
Yes.
What does she say?
She said, yes, I will always be loyal to my husband, no matter what. You and mommy's gonna have to get over that. I don't expect y'all to understand.
Speak up, Mr. Sanders.
Yeah, you can hold the paper up, make sure you're talking to the microphone, but before you read it into the record, I don't recall, did these texts get admitted in the previous hearing?
It was shown to her, I'm not sure Ms. Patel.
Do you recall?
I think it was just used to refresh her recollection, and then she was able to speak about them without just reading them.
Okay, yeah, so if they're not in evidence, he shouldn't read from them. He can read them to refresh his recollection and see where that gets you.
So what does she say to you about her relationship with her husband?
She says that she's loyal to him and that me and my mom will have to get over that.
Get over, say it again.
Well, me and my mom have to get over it.
Get over what?
I guess, get over the situation, like the fact that she's supporting him in the situation.
You said earlier she called you a rat.
Yes.
Is the super cooperative?
Yes.
How did you respond to that?
I talked about how she has a statement and have it on body cam footage, and I said that I guess we're both rats.
In those messages where she talks about you being drunk and wanting to fight, did she talk about you having any type of weapon on you?
No.
That's what I question.
Ms. Feely, do you have questions for Mr. Sanders?
I do, Your Honor. Thank you.
All right.
Mr. Sanders, you testified that you and Mr. Atkins have never fought.
No.
Never had words.
Never.
Never got into other places.
No.
And you testified that this time it was because of the shortcut that you suggested?
That's what started it. Like he made it something bigger out of that.
You testified that you thought you were going to have a physical fight with him about that.
Just about the argument in general, him disrespecting me.
And so that is that's the entirety of what you were going to physically fight about was the shortcut.
Yeah.
And you talked about that you do smoke in your room, is that right?
Mm-hmm.
And Mr. Atkins' children go there because that's their family, right?
Mm-hmm.
Mr. Sanders, when you're answering yes or no is fine, but could you, instead of saying mm-mm or mm-hmm, please say yes or no, because the court reporter can't take down the other things.
Okay.
Or whatever your answer is, it may be maybe, or I don't know, but I need you to verbalize it.
Okay.
Thank you.
And you testified that you were being loud in the car?
Yes.
And it was not until you arrived at your sister's house that the marijuana situation occurred. Is that fair?
Yes.
And you thought she shouldn't be making a big deal about that, right?
Yeah, I thought it was something that could easily been said in the car instead of arguing.
And I think you said Mr. Atkins confronted you about the marijuana situation also?
Yeah, he's the one who's initially confronted me about that. My sister, she just hopped on that when I was leaving. That's when she said something about that when I was leaving.
And you said she's asking the same question?
Yes.
About smoking in the house?
Yes.
And And that's what she was still trying to engage you about when you were trying to back up the car, is that right?
Yeah, after she asked me that question, I rolled the window up and I proceeded to back out.
You rolled the window up after she asked you that same dumb question about the leave.
Yes.
And you were gonna, because you testified you're gonna do it tomorrow, right?
Yes.
And at that point, Mr. Atkins was on the passenger side of the car,
Yes.
and your sister was on,
The driver's side.
and you knew that your sister was 5 months pregnant, right?
Yes, I knew that she was pregnant.
With your niece and nephew.
Yes.
And at the time that you backed up the car, when she was right next to you, right?
Yes.
And when she had her hand in the door handle.
She put her hand on the door handle after I started to back out.
How tall are you, Mr. Sager?
6'2".
You're a bit bigger than Mr. Atkins, right?
Yes.
Your sister told you to go on home, right?
Yes.
And several times in that,
Yes.
when you were in Mr.
And when me and her was having that when she was telling me to go home, I was no longer talking to him because I already asked him did he wanted to fight, and he declined. He said no. So that's when I turned my attention away from him, and me and her were just talking.
So Mr. Atkins didn't want any part of the fight, right?
Yes.
And you were irritated about the way they were talking to you about the smoke, right?
Yes, I was irritated the way he was talking to me. Me and my sister didn't have any conflict.
But she did tell you to go on home.
Yes, she was telling him to go in the house and telling me that it's over to go home.
And that's when she approached the car, there.
She was at the car when I was when I was looking for my phone because I asked her to help me look for my phone, to call my phone.
And you didn't mention anything about the car backing up to the police, right?
No.
Not that night.
No,
Not
she
ever.
did. No.
You told her it was a verbal altercation.
No, I didn't tell him anything at that time. When they was asking me questions, that's when they started to put I'm not sure of the name, but it was something on my leg to stop the bleeding. So at that time, that's when I started to feel the pain, and it was hard for me to talk.
You didn't mention anything about you thinking that you guys were gonna fight when you were in the car, right?
No, not that night, no.
You didn't mention anything about the scene at your sister's house, right?
No, not that night.
Or anything about her being drove by the car.
No.
Nothing further this time around.
Any redirect?
Sorry.
When you asked Mr. Atkins if he wanted to fight, he said no.
Mhm.
Fine, everything is done.
Yes.
When you entered the car, you were doing what Mr. Atkins asked you to do, leave.
Yes.
You were not seeking to prolong any confrontations.
No, I was putting in the address in the GPS so I could leave.
You stated you have no argument with your sister.
No, not at all.
When Mr. Atkins batted on the hood, you got out of the car.
Yes.
You didn't drive forwards.
No.
You confronted him.
Yes.
Because for you, fighting just been physical.
Yes.
You did not reach for any weapons.
No.
Or what?
No.
Please go back.
No.
You didn't attempt to use the car itself as a weapon,
No.
either against Mr. Atkins or Mr. Atkins.
No.
Once you got shot, you didn't react towards Mr. Atkins.
No, I tried. That's when I proceeded to leave. That's when I hurried up and yeah.
All right, Mr. Sanders, thank you. You are free to step down. I don't think, yep, you just take your mask. I don't think there was any papers handed to you.
Your Honor, I still would like to call Officer Ruddock to the stand.
Last name?
No, before we call Officer Ruddock, I'd like to call Mrs. Sanders March.
Okay, Ms. Sanders.
And again, I would just renew the relevance objection since she was not on the scene.
Sure. Before we bring Ms. Sanders in, just preview, what is Ms. Sanders going to talk about? Maybe other than, hey, my daughter reached out to me the next day to say, I'm sorry. I mean, what we heard about.
It was going to be that, Your Honor, what Ms. Atkins testified, said to him.
Okay.
What happened in that incident.
That's the extent of it.
Yes.
Okay.
So one relevance, but two bolstering, if it's only gonna reiterate what Mr. Sanders has already testified to about what Ms. Atkins said, which is already hearsay.
Also, Ms. Atkins testified one version of the facts. He says sometimes put a different version of the facts beyond consideration.
Your view is that what Ms. Sanders is going to say her daughter told her is different from what Ms. Adkins said when she testified. Okay. If we're limiting Ms. Sanders to the exchange she had with her daughter, then I'll allow that.
I would reiterate that it's bolstering if Ms. Sanders is just going to come in here and give us the same version that Mr. Sanders just gave us.
Mr. Sanders couldn't go into detail. See, only heard the speakerphone. Ms. Sanders could testify directly that she was having a conversation with Ms. Atkins.
I'm not going to view it as bolstering of Mr. Sanders. I'm going to view it as a prior inconsistent statement of Ms. Atkins. And we may have heard some of it through Mr. Sanders, but what I'll do, if this starts going on too far, we may say that that's enough. But I think you can call Ms. Sanders. Mm-hmm.
You have a seat. Stay.
Good afternoon, Ms. Sanders. If you could make sure you get up close to the microphone so we can hear you. And you actually can move the chair, but you want to move it forward, not sideways. We don't want anyone falling off. Great. If you could state your name, spelling your first name for the record.
Kim Sanders, Kim.
All right. Thank you for spelling that.
Thank you, Ms. Sanders. Ms. Sanders, how are you related to Angel Atkins?
I'm her mother.
How are you related to Angel?
Can you stand here so that she can talk this?
Okay, that's fine.
Yes.
That's a good idea.
Makes sense. Like really struggling.
Yeah, that's okay.
Happy to know.
So you can be there over to the podium, stay away from the jury box, just because that way Ms. Sanders will be naturally oriented to the microphone, which is her friend today.
Ms. Sanders, again, how are you related to Miss Angel Atkins?
I'm her mother.
How are you related to Tyrone Sanders?
I'm his mother.
How do you know Gary Atkins?
I'm his mother-in-law.
On May 2nd, on or around May 2nd, did you receive a call from Miss Atkins?
I did.
What did she say to you?
Well, the first call, it was just a call. She had already hung up before I got the phone. So I kept calling her until I finally, I got a phone call from Tehran first, and then I got a phone call from her.
What did Tehran say when he called you?
He said, Steve just shot me.
When were you next able to make contact with Miss Atkins?
Maybe about 15 minutes later.
And what did she say to you then?
And she said, Mom, she said, I can't believe all this happened. But I said, what happened? Bubba said that Steve just shot him. And she said, he shot. And I said, yes. She said, where is he? I said, I don't know. He hung up.
Who is Bubba?
Tehran, sorry.
What's the origin? Your son doesn't look to me like a Bubba. He's tall and skinny. So I'm just curious, what's the origin of Bubba?
When he was a baby, I just teased the name Bubba.
That's what it was.
I'm stuck.
Okay. So it's been with him his whole life.
Yes.
Okay.
And did she say she had been hurt in any way?
No.
Did she say where she was when Bubba was shot?
She said that when I asked her what happened, she said, once she located him and everything, because she ran around to where he was. And that's when we talked about what happened after she told me he was on his way to the hospital.
Okay.
But she said, I don't know what happened. I don't know what was wrong with him. She said he was acting funny. When Tehran got in the car, when they picked him up from work, when he got in the car, he said, I know a shortcut. And she said, I don't know, maybe the shortcut wasn't so short. So he started in on him then. And
who started going in on him?
Steve started going in on Tehran.
Okay.
So I need to rewind a little bit. The first thing you described your daughter telling you is, I don't know, he was acting funny. The he is Mr. Adkins or the he is Bubba?
Atkins.
Okay.
So what did she say happened next?
And she said, so he knew about the shortcut. He started in on him then. And I guess to both of their surprise, he talked back to him. He didn't, if you could see his demeanor, he's quiet, he's not aggressive, but he talked back. He
Who's
defended
talking
himself.
back?
Tehran defended himself as she said how he was talking down to him. And she said, but Bubba spoke up for himself.
Okay.
The argument continued. She said they were both heated and they were arguing, and she finally got them to calm down. When they were pulling up to the house, he told her, don't worry about it. You go in the house, I'm going to handle this.
Who told her go in the house?
Steve told her he was going to handle this. She thought that they were going to talk about it. She went in the house. When she saw that they were still arguing, like she thought they were going to fight, she came out to stop it again. Mm-hmm. But prior to them pulling up to the house, he started in on him about smoking in my house.
Okay. And
that's what the second argument was about when they were pulling up to the house.
Okay.
When she goes in the house, she saw that they were still arguing. She comes out and Tehran was looking for his phone. But Steve, when she comes out to intervene, he goes in the house. Steve goes in the house. Tehran is still there because
I'm gonna stop now because you need to make sure, Ms. Charles, that Ms. Sanders is answering questions about what her daughter told her specifically.
Mm-hmm.
Okay, but right now this is a narrative that sounds to me like this is Ms. Sanders's summary of what her daughter told her. And if you want to focus on specific things her daughter said, we can do that. But of course, Ms. Sanders wasn't present for any of this. And so you'll need to be a little more focused in, did your daughter say anything about X? What did she say? Rather than synthesizing of all the things my daughter said, here's how I'll distill it for you.
Thank you. We can do that. Yeah, so Ms. Sanders, did Ms. Atkins tell you who had a gun that night?
She did.
Who did she say had a gun that night?
Her husband did.
Did she tell you what happened as Tyrone tried to leave her house that night?
She said that the reason he was still there, they were looking for the phone. He couldn't find the phone. They've located the phone. He leaves when Steve comes back out of the house, when he's backing out. He said he goes around to the passenger side. These are all her words. He goes around to the passenger side. He leans in and he says, "You're not going to smoke in the house."
Okay, and then where was Miss Angel's hand at the time Mr. Sanders is trying to leave?
She also made a point to say that, I don't know, maybe he thought my hand was on the car, but I had already let go.
Did Miss Atkins tell you she was dragged by the car as Mr. Sanders backed out?
No.
Did Miss Atkins tell you that Mr. Atkins had banged on the hood as Mr. Sanders backed out of the car?
She did.
Did she tell you that the car almost ran her over in any way?
No.
Did she tell you that Mr. Sanders threatened Mr. Atkins with some type of weapon before he was shot?
No.
What did she say Mr. Sanders did after he was shot?
He got back in the car. She said he shot him. He immediately got back in the car and drove off, and that he turned short, and that's how he hit the pole.
No further questions, Your Honor.
Ms. Feely, do you have questions for Ms. Sanders?
I don't, Your Honor.
All right, Ms. Sanders, appreciate you coming in here. And you're welcome to stay in court now. All right, so you were going to call an officer and you said, whoop, nope, Ms. Sanders first. Who was that officer?
Officer K. Ruddock.
Last name?
Ruddock, Ruddock.
Thank you.
My name is Kitwana Ruddock, Kitwana. Last name Ruddock, Ruddock.
Thank you for being here, officer.
No problem, Your Honor.
So where do you currently work?
I'm a U.S. soldier. I currently am stationed at Fort Gordon and I'm on leave from the Atlanta Police Department, where I serve as a patrol officer for Zone 2.
Okay, and were you serving as a Zone 2 patrol officer on May 2nd, 2021?
Yes, I was.
So
what?
I want to, you are currently deployed is the wrong term because here you are in the United States, but are you active duty?
I'm a reserve soldier, but right now I'm doing some MLS training.
Okay.
Gordon.
And we had to pull you from Fort Gordon to testify today.
Yes, Your Honor.
Okay. Sorry about that, but we needed you here. So when you're done, you're not going back to Zone 2 to patrol. You'll be going back to Fort Gordon to blow things up or whatever it is you guys are doing.
Yes, yes.
Okay.
Officer, on May 2nd, how did you find yourself on Cheshire Bridge Road?
So I do some training and I have kind of like advanced life-saving equipment. So I deal with a lot of crime suppression in the area. I heard the call come up over the radio. I went there to support to see if there's anything I can do because it was more or less, it was a shooting victim. So came there to support the shooting victim.
What time approximately did you arrive? Do you recall?
Approximately 1 o'clock, maybe 1:04, around that time.
Once you got to the scene, what were your observations?
When I got to the scene, there was the dark color sedan, a Kia. It was southbound on Cheshire Bridge. There was also a white Lexus with a black male 270 dreads and a woman who was by the car, the dark color sedan. She had like a big backpack, like a black backpack on, and the shooting victim in the car, 2 officers, emergency, EMS, fire, and yeah, the female said she was the shooting victim's sister.
Did you speak to the sister at the scene?
I did speak with the sister at the scene. She was fine. She said that, I'm paraphrasing, but pretty much she was reluctant to talk to me at first. After I spoke to her for a minute or two, she said that her husband had shot her brother after they had a verbal argument at around the corner. It was like Elizabeth Lane or somewhere around there.
Okay. Did you know there's any injury to the victim's sister?
0 injuries. She was fine walking around. Like, she had a really big backpack on. I remember that. And I was like, small female, big backpack. I was kind of questioning that, but.
At any point in her retelling of what happened over at Elizabeth Lane, did she mention she had been dragged by the vehicle?
She didn't mention anything about any injuries. Typically, whenever we get on scene, we ask, is everyone all right? Are there any injuries? Kind of what happened? The only thing she would say was that her husband, and she, mentioned him with his name, shot her brother, and he had a gunshot wound to the leg at the time.
Overall, how would you describe her demeanor?
She's cooperative, calm. Her main concern was getting the vehicle back to her mother or his mother. Well, I'm assuming they have the same mother. When we told her she couldn't do that, she got a little bit upset because for whatever reason, but that's really all I can remember about her demeanor. She never complained about anything.
Once you spoke to her, what did you do next?
So I secured the crime scene, just make sure, or the scene where the victim was recovered. Then I followed the victim to the hospital, to Grady, just to kind of check on him to make sure everything was okay, and so that nothing else would happen, just in case something else was to go.
And while at Grady, did you have any interaction with Mrs. Sanders, the victim?
I did. I had interactions with both him and his brother, who came to the scene, stayed with him that night. He kind of told me his recollection of the events that happened.
The brother did, or Mr. Sanders did?
So the victim, shooting victim, his brother was in town, and his brother came to the hospital,
right,
and spent the night with him there.
Got it. But I was trying to follow. And this brother who was in town, he shared with you, here's what I think happened, or the shooting victim shared? Okay, that makes more sense. I misheard you.
Did the shooting victim, Mr. Sanders, was he able to give you the entire story? What was going on at the time while you were
yes, ma'am,
speaking with him?
So I asked him what happened. He said he was coming home or going back to his sister's apartment. When he got to his sister's apartment, there was some arguments in the vehicle or whatnot. His sister got out the vehicle, and her husband got out the vehicle. And when he came, her husband told, is a lot of he and she, but the husband told the sister to go in the house. So the sister went in the house. Then the husband got into a verbal altercation while the husband was outside the vehicle with the shooting victim. The shooting victim tried to leave when the husband slammed on the hood of the car. He slammed on his hand on the car. The sister came back out. There were some more arguments. Whenever the shooting victim got out the car in the door jamb of the vehicle, the husband then pulled out the firearm, shot the victim. Victim immediately got back in the car and took off. And that's where we found him on Cheshire Bridge Road.
Thank you, Officer. No further questions.
Ms. Feely, questions for Officer Ruddick?
Thank you. Now, you weren't on the scene at the Elizabeth address, is that right?
Negative. I wasn't at Elizabeth. I was on Cheshire Bridge Road, and then I was also at Grady Hospital.
So you didn't see anything that happened at the actual shooting location?
Negative.
And you mentioned what the shooting victim told you had happened, right?
The shooting victim and his sister.
And you mentioned that the sister, Angel, had a large backpack, is that right?
Black backpack. She was concerned about getting things out of the vehicle since we weren't able to release the vehicle to her to take it back to her mother.
And so, to your knowledge, she was just allowed free range in and out of the vehicle?
Not to my knowledge, no. I never saw her go in the vehicle. I did speak to her while she was outside the vehicle.
And you're aware that she arrived to the scene on foot?
I'm not aware of how she got to the scene. There was another person with her at the time that had also driven to the location.
But it was your understanding that the book bag came from the vehicle in question?
Negative. I just knew that she had a book bag on her back. I don't know where she got it from.
And to your knowledge, did they impound the car
Correct. The car was taken to my knowledge.
and they searched the car?
I have no idea. I left before the vehicle was removed from the scene.
And you mentioned that the sister was reluctant to say anything at first,
For about 2 to 3 seconds, and then she opened up.
and her main concern, you testified, was getting that car back.
Her main concern was not getting her husband in trouble and getting the vehicle back.
Not getting.
In
her
that
husband-
order.
Not getting her husband in trouble.
Correct.
But this was the car that the shooting victim was most recently in, is that right?
Correct.
And Mr. Sanders didn't tell you about the argument involving the marijuana smoking?
He did. He mentioned that, I'm paraphrasing, but he said to the effect of, it was something minor, like smoking weed in front of the children. And I asked him, I said, what did you say to him? And he said, I didn't have a problem smoking weed, so I didn't think it was gonna be a big deal. But the suspect said it was a big deal, which was kind of weird. So I don't know why he'd make that big of a deal of it. And he seemed like he was trying to agitate the situation.
By not wanting Mr. Sanders to smoke weed around his children?
Negative, by escalating the argument. Because the argument, I guess, probably started when they were driving and then continued when the victim came out to him at the vehicle.
And Mr. Sanders didn't tell you about his sister also getting on his case about smoking weed around?
I can't speak to exactly how he phrased it, but my assumption was that all three of them were in the argument together or conversation together.
And he didn't tell you that both Mr. Atkins and Mrs. Atkins were at the car when he pulled off?
He did mention that all three of them were present on scene when he was trying to leave.
And he didn't tell you that they were having a conversation through the window before he left?
He did tell me that he was in the vehicle and both of them were outside the vehicle when it was him.
And he told you that they again tried to engage him about the smoking weed? He'll be back.
In that order, I'm not sure, but smoking weed was at the center of the conversation.
And he didn't tell you that while she was trying to speak with him, he rolled the window up?
He never mentioned anything about any windows going up or down, just that the suspect was trying to get into the vehicle from the passenger side.
So Mr. Sanders told you that Mr. Atkins was trying to enter the vehicle from the passenger side.
At one point in the conversation, in the argument.
But focusing on when he pulled out of the car, pulled out of the driver to leave, you said he was trying to leave, right?
Correct.
And he told you that Miss Atkins was standing right by the vehicle when he pulled out.
Objection, Your Honor, asked and answered.
If you just want to clarify one last time, you can do that.
Mr. Sanders told you that Miss Atkins was standing next to his driver's door when he came out.
Negative. He told me at some point in the altercation or while they were talking that she was by the vehicle. I can't really speak to, it's been over a year, so I can't speak to exactly what moment he told me she was at the vehicle when he was pulling it.
Sure, but you testified on direct that she was in the house when we were out.
Negative. I said that the suspect told her to go in the house, and at one point he stated she went in the house and then returned out.
And I'm not trying to get on your case
That's fine.
because I know you weren't there, right?
Correct.
And you're relying only on Mr. Sanders' information that he provided.
Mr. Sanders and his sister.
And the statement from Ms. Atkins was reported as well, right?
A firm.
Is that all, Ms.
Yes,
Yu? Okay. Any redirect?
Officer Reddick, throughout your entire conversation with Mr. Sanders, did he ever mention having a weapon?
Negative.
Did he mention trying to find a weapon?
Negative.
During a conversation with Ms. Atkins, did she mention her brother ever having a weapon?
Negative.
Did Ms. Sanders mention her brother driving the car at or towards her?
Negative.
Did Ms. Atkins mention Mr. Sanders trying to drive the car at or towards her husband, Mr. Atkins?
Negative.
Did Ms. Atkins mention having her hand on the car as it was going backwards?
Negative.
Did Ms. Atkins mention she was dragged by Mr. Sanders' car going backwards?
Negative. And there was like no indication like that she was shooken up or anything. So, I mean.
Thank you, Officer. No further questions.
May Officer Ruddock step down?
If I just wanted to clarify one thing about the search of the vehicle, if I may, just as a redirect.
Or recross? Sure.
I didn't write down, did you say you didn't know whether the vehicle was searched or you know the vehicle was not searched?
I wasn't present through the entirety of the vehicle being there. My sole purpose was to secure the scene to ensure that nothing happened while I was there, and then to accompany the shooting victim to Grady to make sure that he was okay.
You don't know whether the car was searched for weapons?
A firm.
Thank you.
Thank you, sir. Appreciate your time.
No problem.
Thanks for your service.
Thank you, Your Honor.
Thank you. Nothing further from the state, Your Honor.
Okay. Any rebuttal testimony?
If I could have just one more.
You may.
Your Honor, we would like to briefly call Cheryl Jamison Atkins.
Okay. One of you will need to go get her.
I saw a friend.
Good afternoon, Your Honor. My name is Cheryl, Cheryl Jameson, JAM, as in Mary, ISON hyphen Adkins, AD as in David, KINS.
That was one of the best enunciations and spellings of names ever. Thank you.
Retired court reporter, Your Honor.
Oh, no. You're showing the love then. Because Ms. Rivers is like, I can hear everything she says. It's a beautiful thing. So thank you for that. Continue to speak up the way you are. Others can learn from that. All right. When you're ready, Ms. Feely.
Thank you. How do you know Mr. Atkins?
He is my son, my only child.
And do you know Angel Atkins?
Yes, she's my daughter-in-law.
And how long have you known her?
I met Angel on my birthday, August 2, 2013, at her place of employment, which was the Skywheel.
Oh, the Atlanta Eye.
Yes, the Atlanta Skywheel. Yes, she worked there. And my son took me for my birthday.
And do you know Mr. Sanders?
Yes, I do, in relationship to Angel.
And how long have you known Mr. Sanders?
I would say I probably met him shortly after my granddaughter was born. So she is 7 years old, my oldest.
So fair to say that Mr. Atkins and Mr. Sanders have probably known each other about 7 years also?
Yes. Mhm.
All right, and because this is a pretty narrow issue that we're discussing, let me turn your attention to May 2nd.
Yes.
Did you speak with Angel Atkins on May 2nd?
Yes, I did.
Can you tell the court what she told you about this incident?
Yes, I arrived at the scene. I was at the first scene, which was my home, 2445 Elizabeth Ann Lane.
Well, that's your house. That we've seen pictures of a house. That's your place.
Yes, it is. It is a triplex, Your Honor. So there are 2 units that you can see from the street and 1 unit around back. I was in the unit around the back. However, I did not hear the incident as it was occurring.
So your son and your daughter-in-law live in one of the 3 units of the triplex, or they live in your unit?
No, they live in one of the 3. They live in unit B.
Which is one of the street-facing units?
Correct.
And you're in the back?
Well, I was occupying the back. My father, before he passed, lived in the back. I actually live in the other front unit, which is where I am most of the time. But at that time, due to air conditioning issues, I was in the rear.
Got it.
Yes. Mm-hmm.
What did Angel tell you led up to this incident?
Angel was very hesitant to say a lot. I felt like I had to pull it out. In fairness, my son had spoken with me within a half hour of the incident. So I, knew what he was saying occurred. So when I saw Angel, the first time I had driven over to see, was she okay? And at that point, I encountered one of the same police officer, I think, one of the police officers. At that point, Angel was a little resistant to talk to me. She was sitting in the car with a Good Samaritan that was just making sure she was okay. I came back about an hour and a half later, and that is the time when Angel then sat in my car because we were still waiting on GBI. I asked Angel what happened, and she said, he shot him, he shot him. And I said, what happened, Angel? What was going on? And she said to me, it doesn't matter anything that happened before the gunshot. Whatever happened, he didn't deserve to be shot. So that was what she said. I then said, well, was there an argument? She said, well, yeah, but it doesn't even matter. And I basically feel like I had to pull it out of her. I said, did your brother, drag you? Well, and her response was, he didn't know I was there. Again, more to me, sort of a little bit, well, I'm sorry, I won't characterize it. I then said, were you,
Is she testifying to what Ms. Atkins says to her, or what she's asking Ms. Atkins? I'm not sure how she would know about the dragging if Ms. Atkins hadn't said anything about the dragging up until that point.
Well, tellingly, Ms. Jamison Adkins said, I'd already spoken to my son. So you'll be able to ask her questions, but it seems to me the only way Ms. Jamison Adkins could know about what happened would be the conversation she had with her son. She testified it was within 30 minutes or so of the incident. And as I'm understanding the timeline, this discussion, Ms. Jamison Adkins and Angel Atkins, is happening after Ms. Jamison Adkins' discussion with her son. So you go with that where you will. Ms. Feely is focusing not on the discussion with son, but discussion with daughter-in-law.
so Angel then said to me, he did not know that I was there. I said to Angel, were you screaming? Were you loud? Did he hear you? She said, no, I wasn't screaming. I wasn't loud. I said, Angel, were you whispering? She says, no, I wasn't whispering. Okay, yeah, I was talking loud, but it wasn't like I was, we weren't screaming. So basically, again, just saying as little as possible regarding that. But she did admit that he did pull her. He did drag her.
That's all I have at this time, Your Honor.
Okay. Ms. Charles, any questions for Ms. Jamison Adkins?
Yes, Your Honor. You testified that in your conversations with Ms. Atkins, the first thing she said when you asked what happened is he shot him.
Yes, words to that effect, correct.
And that was after having spoken to your son.
Correct.
And you testify that Angel said Mr. Sanders did not know that she was there as she backed up the car.
Those are the words that she said. He didn't know I was there. That's what she initially said. She later changed it. She later corrected it to, okay, yes, but.
After she said he did not know I was there, you testified that she wasn't screaming. Is that correct?
I testified that I asked her, were you all loud? Were you screaming? Could he have heard you? And she said, no, I wasn't screaming. I then asked, were you whispering?
And she said, I wasn't loud.
No. She said, no, I wasn't whispering. So I said, Angel, were you speaking loud enough for him to hear? And she then admitted, okay, yes, I was, but he looked the other way. So again, you can make whatever characterization.
So did she say she was not speaking loudly and not screaming as the car was going in reverse, or during the initial encounter when they had that argument?
She was specifically referring to the point in time when she was banging on the window. And that's another part, I'm sorry, that I did not mention. She did say that she was holding the handle and,
banging on the window.
Yes, of the car as he was backing out.
At that time, when she was banging on the window, did you say he was backing out or he was getting ready to back out?
He was backing out. And she had her hand in the, there's usually a little lip, so to speak. She had her hand there.
So if she was banging on the window as he was backing out, he would have known she was there. Isn't that correct?
That was my point exactly, counsel. That was my point exactly.
When you said Angel was saying as little as possible, was it
about Mr. Sanders or saying as little as possible about her husband's involvement?
She was saying as little as possible regarding her brother, as little as possible. Even when I noted that the passenger door was open and I asked her, why was the passenger door of Kim's car opened?
The passenger
But
door
that
was
was-
open
Yes,
when?
After it had come to rest, on Cheshire Bridge. When I arrived at the scene, Mr. Sanders was already gone. The car had come to rest. And not only was the driver's door open where he would have gotten out, but the passenger door was open. And I thought that was strange, Your Honor. I asked her and she said, I was in there getting his stuff together. She didn't say she was helping with bleeding. She said, I was in there getting his stuff together, which gave me pause.
At any time did Ms. Atkins mention to you seeing her brother with any kind of weapon?
No, Angel did not mention seeing her brother with a weapon. She did mention getting his stuff together.
Okay.
That was in the backpack.
Did she tell you where she had met up with Mr. Sanders that day?
No, as I mentioned, my daughter-in-law, Angel, did not get into the details even about the argument. No, she did not.
Okay.
Her focus was really on her brother. She was concerned about her brother, and that's where her focus and, to me, her allegiance was on that.
Why did she tell you about Mr. Atkins banging on the hood of the car?
Angel did not tell me that part. That was my son that told me that when Bubba, that's the name that we call him, Bubba, Bubba. My son told me that when Bubba was backing out and Angel was holding on, he was dragging her, he went like that. In other words, I know the record can't reflect that, but he banged on the hood of the car to get his attention. He then said, Bubba stopped, looked over to his backpack, and then, again, this is what my son said, appeared to reach for something in his backpack, and then got out, and immediately that is when the incident occurred.
When?
Incident meaning your son shot Bubba?
Incident meaning the gunshot.
Well, do you think someone else shot Bubba?
No, I have no reason to believe someone else shot Bubba, Your Honor.
Okay.
When Mr. Sanders got out of the car, was he holding anything in his hand?
Well,
I
she's
wasn't
not there, so
Yeah.
that's not a
We didn't
question she
say.
can answer.
So so your son told you that he shot at Mr. Sanders because he was reaching, or he appeared to be reaching to his backpack.
Absolutely.
It wasn't because he was dragging Miss Atkins.
It was both, counsel, but when my son represented to me that he felt threatened because he didn't know what he had retrieved from the backpack. He said to me when he was dragging Angel, his concern was that at that time, Angel was how many months? 5, 6 months pregnant. She gave birth in September. So whatever the months was, she was pregnant, and she was, had been just immediately being dragged. He banged in that regard, but then when Bubba stopped and reached over and then jumped out, now all of a sudden, my son represented to me that he felt a threat. He felt threatened. He didn't know what he was going to do.
Where was your son prior to coming around to Mr. Sanders?
Counsel, I can't answer that. I was not
I
on the
wasn't sure if
scene.
he had told you where he was.
But you
before he
should
left.
ask, did your son tell you where he was, whatnot?
Did your son tell you where he was prior to banging?
Prior to banging?
Yes.
Because he had to walk around to the front of the car to bang.
Mm-hmm.
Prior to that, he basically said that they were arguing. They were in the yard arguing,
Did your son tell you how long the dragging of Angel happened, the alleged dragging happened?
I believe he said it was a process. He didn't say it was 2 seconds or it was 10 seconds, but it seemed to be a process that he didn't seem to stop, meaning Mr. Sanders, to the point where my son had time to walk around and to bang.
When he shot at Mr. Sanders, did your son tell you whether the car was moving or was it come to a complete stop?
My son did not tell me that information.
No further questions, Your Honor.
Ms. Feely, any redirect of Ms. Jamison Adkins? No? Okay. Thank you, ma'am, for your time. Appreciate it.
Thank you, Your Honor.
Any other witnesses for the defense?
No, Your Honor.
All right. Then we'll call the record complete. I'm happy to listen to argument if you want to make it. This is fairly fact intensive. And so my thought is I will review the record and let you know if I think the defense has met its burden here by way of a written order, but I don't ever want to preclude folks from making an argument at this juncture. I don't need any written submissions later unless if I'm stumped on a legal question, I'll get an email out to both sides saying, hey, if you've got any case law that would help me navigate this, please share it. But I think I need to line up all the evidence I've heard from people viewing this from different perspectives and hearing it from different people, and then see where I think that falls on the spectrum of burden of proof that the defense has. So Ms. Feely, if there's argument you want to make, you're welcome to do so, or you can leave the case with me and I'll take it from here.
If I could just briefly, Your Honor.
Sure.
So as the court is aware, we're looking at 16.321 justified use of force. And I already pointed out that it is to prevent death, great bodily injury, or the commission of a forcible felony. We're operating under that. And I just wanted to point out just a couple of case sites in the court. And I am still new enough that I didn't have Westlaw access to actually print, but if I could provide some citations.
Please, and for future reference, the citations are what I prefer and not a copy of the case, so save the trees. It's just the case citation. I mean, give me the name of the case, but with the citation.
So Bunn versus State 284 Georgia 410, 2000.
Bun as in sticky bun,
BUNN
284 Georgia.
410, 2008 case. It is a self-defense immunity motion type case, but I bring it up also about the just standard of proof. It's the first one of the cases that talks about that in this context, that preponderance of the evidence means a superior weight of evidence upon the issues involved, while not enough to free the mind wholly from reasonable doubt, sufficient to incline a reasonable and partial mind to one side of the issue or the other. So basically, I want the court to keep in mind that if the court is saying this is a question for the jury and deny the motion, that means that the court is completely even on where the evidence lies or believes that Mr. Atkins was not acting in self-defense.
It's like a civil case. This is basically the civil burden of proof.
Right. So if the court believes that was self-defense, even just a little bit more, that would be, the court would have to grant our motion at that point. We also point out State versus Green, 289, Georgia 802. It's from 2011. It talks, it's again an immunity motion case. And some of the language, a mere threat of force is all that's required when one reasonably believes that he must defend himself against another's imminent use of lawful force. And it also talks about the decedent being totally irrational. The defendant didn't know what the person could do. And I think it's very similar to some of the facts that we saw here. And in that case, there wasn't a weapon or a car or anything that could be used as a weapon brandished by the decedent. And State versus the second, apologize, Your Honor. I'm flipping through too many pages. The second case is 297 Georgia 222. It's from 2015. This is also a case where the deceased was unarmed, and again, very fact specific, but the threatening behavior was days before, not even minutes and seconds before, as we have here. So just going through the elements, Your Honor, reasonable belief. We would point out that as the state showed in their photographs, this is after midnight, it's dark outside. Mr. Atkins is in his own driveway. The testimony was that Ms. Adkins asked Mr. Sanders to go home repeatedly. And then we see it escalating to threats and intimidation. That Ms. Atkins testified about him getting physical with her, moving her, pushing her, and then the dragging of her with the car. And Mr. Sanders admitted that he was irritated that they were getting on his case about smoking, and that Ms. Atkins was trying to continue to engage him on that topic that he did not want to talk about anymore when that situation arose. So there, and again, I would argue that there is not a lapse of time sufficient that threat went away between the dragging and the shot. So we would just submit that we have shown by a preponderance of the evidence that the shooting was justified under the statute.
All right.
Your Honor.
Thank you. Yes, ma'am.
That's right. Your Honor, a person is only justified in using deadly force or threatening force against another where he reasonably believes that that force or threat is necessary to prevent imminent threat. Mr. Atkins cannot now legally avail himself of this defense when he intentionally placed himself in a confrontation with Mr. Sanders. Your Honor has heard evidence that Mr. Sanders was attempting to leave the situation. The situation had been sufficiently diffused where he was simply going home. Mr. Atkins banged on the car and stopped the car. Mr. Atkins then walked around from the passenger side where he had been formerly standing, came around to the driver's side, again confronting Mr. Sanders and shooting him once in the thigh. At a time during the course of events, there was no threat or no danger to anyone in that moment, either to Mr. Atkins or Ms. Atkins, if we're to believe her testimony, that for 2 or 3 seconds, as Mr. Sanders is backing up, her hand may have been on the handle. And then she, for a little bit, as she testified on February 15th, she may have lost her footing, but she quickly regained her footing. At best, for the defense, Your Honor, Mr. Sanders, when he exited the vehicle, he was gearing up to have a physical fight with Mr. Atkins. There is no mention in any of the evidence that we've heard, either from Mr. Sanders, this defense's rebuttal witness, any of the officers, Ms. Atkins herself, that her brother was armed. Her brother had a backpack because he was coming home from work that day. We've heard testimony, Your Honor, from Officer Ruddock. You saw in the first part of this hearing, the body cam footage of Ms. Atkins at the scene. She was calm, she was collected, she wasn't hysterical. At no point did she mention she had been hurt. Her primary concern, as we saw in the body cam, Your Honor, was concern for her husband. Her words were exactly, I am in a tight spot.
She is.
And we understand that, Your Honor. This is her husband, this is her brother, this family. However, Mr. Atkins cannot use deadly force and shoot at Mr. Atkins when Mr. Sanders posed no threat either to him or to Ms. Atkins. And it stretches credibility to say that she was being dragged when she herself testifies to her mother, to her mother-in-law, that maybe Mr. Sanders wasn't even aware that she was there. She wasn't screaming, she didn't shout, she didn't say much of anything besides initially as he's getting up to reverse away, hey, make sure you don't smoke when you get over to mom's house. That is what she said to him. He blew her off and proceeded to go home. Mr. Atkins interrupted that course of events, and Mr. Atkins unjustifiably shot at Mr. Sanders, and he cannot today claim self-defense. Mr. Atkins was the aggressor. In that space of time, Mr. Sanders posed no threat Mr. Sanders was the aggressor. There was no threat to him or Ms. Atkins, and therefore we ask that you deny his motion for immunity because he cannot, under OCGA 16331, claim self-defense. There was no risk of great bodily harm. The statute is very clear. It says great bodily harm. Ms. Atkins stumbling does not rise to the level of great bodily harm. And therefore, the defense does not meet its burden by proving by a preponderance that the use of force was justified.
Thank you, Ms. Charles. All right, I will take this under advisement. I've got my notes from both sessions. We've got the transcript from the first session and the motion. So I've got everything I need. I will get an order out as soon as I can. If I grant the motion, we're done. If I deny the motion, then we'll need to make sure Mr. Atkins's case continues to move forward at a healthy clip. Any discovery issues that you're aware of? You've been focused on other things in this case, along with lots of other cases. But I guess if you would just make sure, Ms. Feely, that there's nothing that you think is missing in case we are going forward. I want to make sure that there wouldn't be an obstacle to getting the case on a trial calendar in fairly short order.
That would be a priority for me as well. As the court can see, Mr. Atkins in Orange has been in custody for quite some time. So
I thought Orange meant Cobb County. It does. Okay. That doesn't mean he's been in for a long time. It means he's at a place that I hear folks don't want to be. So not that they want to be in any of these facilities, but I'm anxious to get closure on this case, whatever that's going to look like. It's dismissed, or we press forward to trial or a non-trial resolution if that's where the parties get. I appreciate everyone's time. I also appreciate that this is a complicated familial situation. I would ask folks to maintain decorum. You're going to have to intersect in certain ways. Poor Ms. Adkins is going to be thinking about her husband, thinking about her brother, her mom, and we just need to make sure that everyone treats everyone with respect until this is over. When it's over, I hope you continue to do that, but between now and then, I definitely need that, because if there's any hint that someone's trying to influence someone in either direction, that's going to be a problem that we'll need to address. So everyone stay in their lanes and do their best to maintain composure while we try to get through all this. Ms. Charles, anything else in the Adkins matter? Okay, Ms. Feely? All right, thank you, everyone.